petition stands allowed, and the case against the present petitioner in issuing process against the present petitioner is hereby set aside and quashed. However, the case against the other persons will continue in accordance with. The order dated 21/09/2022, passed in Miss PG case number 86 of 2026, hereby set aside and quashed, and matter is remanded back with direction to the District Judge Hailakandi to issue frame issues on the point of limitation, again giving an opportunity of hearing to the both sides. The matter will be decided accordingly.
May I please, Your Lordship?
Yes.
May I please, Your Lordship? So with the consent of the respondent, I beg to mention item number 8, which is maybe kindly adjourned today and maybe fixed in last week of February.
You are for the
Petitioner.
petition. You have taken consent of the
Yes.
I'm for the 1 and 2.
with consent of the other side and the ground of personal inconvenience. The matter. You want here a fixed date or last week of February?
Fixed date, Lordship.
It is creating problem in us, in because especially in civil matters, fixed date 27th of February.
Lordship. Lordship, I have the similar prayer in respect to item number 9. Here I am for the respondent, Lordship. I have taken consent of the petitioner, Lordship. This may be also last week of February, Lordship.
Here you have taken consent of
Yes.
the petitioner side.
Yes, Lord.
Do you know, is there any
Yes, interim order is
interim
there.
there?
Yes, there.
Consent of the same orderly interim consent of the other side and consent of the respondent paid by it. Interim be continued the next date of listing. We're listing it on the. We're not going to fix the matter. We're listing it on last week of February.
Lord.
List the matter on last week.
March.
May I please, my Lord? Lordship, with regard to item number 16, Lordship, I'm taking some accommodation.
1/6.
1/6.
You are for the.
I'm for the petitioner, Lordship. Due to
It is in order column, I think. Na?
Lordship.
Oh, in admission
Yes,
column. You are Mr.
Circle.
S.
Circle. On behalf
Sarkar. You are appearing on behalf of
of
Mr.
Mr. S.P. Chaudhary.
S.P. Chaudhary. But Mr. S. appearing on for the petition, citing the ground of inconvenience on the part of the engaged counsel by right of prayer. Mr. Matter accordingly. After 3 weeks,
Lordship, there is an interim order in this.
interim must.
Lordship.
After 3 weeks, interim be continued till next date.
I love it.
May I please, Your Lordship? So I beg to mention item number 7. In this matter, I am appearing for the petitioner. They have instructed me to hand over the bit to another advocate. So they want to engage some another lawyer in this matter. So I have accordingly handed over the brief to them. And I will thank you today for that. So they will
You have filed your workout number? No, not yet. Otherwise, you are for the petitioner.
I am for the petition.
You are Mr.
D. Chaudhary.
D. Chaudhary. Heard Mr. D. Chaudhary. Then the petition also heard Mr. S.M. Abdullah for the land council for the response. However, it is submitted by Mr. Chaudhary that as per his fact, they have already handed over the brief to MS. A. Begum and who will be filing our Bakaratnama. MS Begum also appeared and submitted that they will be filing their Bakaratnama during the course of the day and accordingly paid for an adjournment. Considering the submission made by non-council proposals. Matter 2 weeks after we'll do. After 2 weeks we'll do. Fixed to in that case we will go in the last month of March because we don't have the date. All the civil matters, if this is for fixed date, then it will be difficult for us also to get it over. Now, we are March or Pispale Joga. 25th of March. Your name should be deleted. Now, here, Mr. T. Chakraborty, your name and
Yes.
Mr. J. Das, these are there. So we delete all the
All.
group name. Further registry is hereby directed to strike strike of the name of the learned and learned, 4 learned and guest council which are reflected in the cause list on the next date of list.
Much like
May I please look? And back to mental look, item number 11 look. But to kindly matter may be taken up after 3 weeks. Look. I have taken consent from the others.
So you are for the petitioner or for the
I
respondent?
am for the petitioner.
The consent of the respondents, the learning council appearing paid for an adjournment. Allowed. This the matter accordingly after 3 weeks as an date. Was there any interim?
Yes, look.
Interim was there.
Interim.
Interim be continued. till next.
Wait, please, Your Lordship. The counsel for Creator could not appear due to demise of a close one.
In which item?
Supplementary item 39. Taken the consent from the other side. Your Lordship may kindly fix the matter.
Cavator, in a sense, you go for the appearing for the
Yes,
respondent.
yes.
Have you taken consent of the other side, that is
Yes.
the petitioner?
Yes.
With the consent of the other side. The learned counsel MS, your good name?
B.R. Shah.
B.R. Shah appearing on behalf of Mr. N. Chakraborty
C. Goswami.
C. Goswami for the caveat rate for an adjournment to which your Biswas, you are here.
Yes.
Mr. S. Biswas, the learned counsel petitioner is no objection. List the matter when it can be.
Monday, 9th.
Yes, Biswas, any
the second, the matter is being reported already court of execution. So
22nd.
yes,
They are also to 5 and 5. We can fix it on 11th of February.
Much obliged.
May I please, Lordship? Lordship, with the consent of others, I beg to mention item number 25, Lordship. Kindly agenda matter for a day, Lordship.
You are for the appellant or?
Yes, Lordship, appellant.
Yeah, that's-
Lordship,
Done.
interim order is there, Lordship. It may continue.
Huh?
Interim order is there.
the learned counsel appearing on behalf of the appellant for an adjournment. Your good name?
Lordship, I am appearing on behalf of Shoma Das Gupta, Lordship.
Madas Gupta. Your good
P. Odigari.
Huh?
P. Odigari.
your appearing on behalf of Ms. Shobha Das. Interim be continued till next date of listing list accordingly after 4 weeks.
May it please your leadership. I beg for item number 17 and 18 and seek for an adjournment. As my senior is out of station due to attend his mother-in-law.
Who is your senior? Who is your senior?
Tikedas.
DK Das. He is not available today?
No.
Have you informed the other side?
Lordship, I am for the respondent, Lordship, that may be fixed on 25th, 26th, it is fixed for the trial court.
Can we
Authority.
fix on 6 or 7?
No, Lordship, it is 26 there is speech, and every time, Lordship, they've submitted there that we are taking time in the execution proceeding. But if you Lordship go through the record, Lordship will find that the appellant has been taking time and time. So kindly maybe fixed on 25th. 26th, the case is fixed. Before the
The execution is fixed.
Lordship. Before that,
Your MS, your good name?
Mamoni M. Khatuniya.
Hard MS M. Khatuniya, appearing on behalf of Mr. T.K. Das for the appellant paid for an adjournment, stating that he, due to his personal inconvenience, he could not appear before. Mr. A. R. Shown, the learned counsel, appealing for the response, raised objection and submitted that on the several occasions the appellant had already took adjournments and the execution is still pending. Stop. In view of this, let the matter be. You are saying
25th, Lordship. 25th February.
25th of February.
Hmm.
So both are the rewrite.
Both are the rewrite.
Rewrite.
17 and 18, Lordship.
কোনো বড়ুয়া একটা রেকর্ড দিল
Concurrent finding, Lordship.
Hey, where is the original document passed by
Original
Court
judgment,
of
Your Lordship.
Reda?
In error appeal 5, Your Lordship, the page 14 starts from page 14.
No.
And
No, I have just checked for a reason, that's why. Otherwise, no issue. The who passed the order on Rera, that's what
Yes.
I'm just saying.
Yes.
Okay, then otherwise we're fixing it on 25th of February.
25th, Lord. 25th February. Both the appeals, Lord.
Yeah, both there.
Yes. Oblige, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 22. Lordship, we are, for the petitioner, we are newly engaged in Thai local number. But Your Honor, Lordship, our name was not shown in the cause list.
You are for the respondent.
Lordship,
You are for the respondent, for the petitioner.
petitioner.
You in which item you are saying? In item number 22?
22.
The name of the advocates of the appellants are being shown here.
We are newly engaged, Lordship. And we file local number.
How you are newly engaged? Have you informed the counsel for the other side?
Yes, Your Honor. They send, they give NOC.
Where is the NOC? Have you placed it?
Yeah, Lordship.
You are MS?
B. Doctor, on behalf of SR Gogoi.
B. Doctor.
B. Doctor. Lordship, kindly, matter may fix for hearing.
Why hearing? It is an order column. We have received the, no, the respondent, they appear here,
No, Lordship.
then why, how can we fix it for hearing? Let your turn come, then only we call for the record. We have to see the record, huh? Just see.
Please, your lord. Your lordship, with the consent of the other side, I beg to mention item number 6 of today's list, your lordship. In that case, we required some more time to file our objections.
You are for the respondent,
Yes,
I'm
your
for the
lordship.
petitioner. Madam.
you are for the petition.
Yes, last time they sought time for filing objection. So till now they have not filed, so let him file an objection.
On the last occasion also you took time.
Yes, your lord.
Heard Mr. Ada still on it. The also heard Mr. Yeah, Mr.
M. Sharma.
Verma.
M. Sharma, the Learned Counsel appearing for the and submitted that he needs. How many weeks you need here?
Lordship, 3 weeks maybe.
3 weeks time.
Let
I
it
did-
come after 4 weeks, my lord, because after 3 weeks again, if they
Yes,
take
that
some
should
time,
not
that is right.
give
In the
time to
meantime,
file the written objection. In that context, Mr. Das, the Learned Counsel for the petitioner submitted that this may be considered as a last chance for filing the written objection and submitted that the respondent may be directed to file the written objection on the next on considering the submission made by Learned Counsel for good sense. Let the matter be listed after 4 weeks.
4 weeks.
4
Lord,
weeks
interim order was there, interim.
as on a date to be picked by the registry with the direction to the respondent side file their written objection without fail on or before the next date. The interim be continued till next date.
I'm deeply obliged.
Yeah, please, your lordship. Lordship, can you call for the TCR at this stage?
TCR will be required.
TCR.
My lord, here it was earlier rejected, my lord.
Yes, sir,
After
it was
going to that
rejected.
case in court, my lord, it was rejected only on my lord 16/12, my lord. It says perhaps there is no new grounds, my lord, for filing the petition, my lord. As Sarsit already, it was rejected only on 16/12, my lord. That is page 101, my lord. Perhaps there is no new grounds, my lord. And after going to the record, my lord, PCR and materials, my lord, it was rejected.
In this case, lordship, in as much as 6 persons were there, lordship. Out of those 6 persons, 5 were granted bail. And from this person, lordship, nothing was recovered. On the last occasion, lordship, while lordship was pleased to reject the bail application, last 2 lines I am reading, it is an admitted fact that person cannot be convicted on the basis of the statement made by the co-accused under section 67 of the NDPS Act. But during investigation, the statement of the co-accused may be the basis of investigation. I will argue on this point, lordship, as to whether 67 can be taken at the stage of bail or not. Therefore, lordship, without arguing the case, my simple prayer today is lordship may kindly call for the TCR. Otherwise, lordship, the petitioner almost he has completed 1 year and nothing was recovered from his post. Lordship may kindly call for the TCR.
Heard Mr. Emma. Heard Mr. Bishop. The Learned Counsel VP appearing. Scan copy of the TCR along with the case diary we call for. Registry will do the needful for where from it has to come.
Sribhumi, lordship.
Sribhumi. One time. We're listing it on 15 or 16. Let
Yes,
the 4,
yes,
16.
highly obliged.
My please, Lordship. Your Lordship, this petition is filed against the impugned order 17/12/2024, Lordship. And arising out of title suit number 103/2020,
The suit was basically filed for specific performance on the basis of an oral agreement, Lordship. And at the time of execution of the original oral agreement, the PW number 4 owner was present, and accordingly, the plaintiff desires to adduce the evidence of the PW4 owners. But by the impugn order, though
Where's the
adjournment was sought.
Order. Where is the
Yes,
order?
Lord. Yes, Lord. And next year you flip. At page number 46. The adjournment was sought only on the ground of medical issue, Lordship. But considering the length of the time taken by the plaintiff for filing of PWs, the learned court below was pleased to reject the adjournment petition. On the very previous date, the PW3 was filed. So accordingly, the plaintiff was ready, but due to medical issue, Your Honor, the same could not be done, Your Honor.
You have not submitted the order sheets.
At page number 46.
Now, how can we say that you took adjournment one occasion, 2-3 occasion, all
Yes,
was
Your Lordship,
medical
all
ground?
the
There's
whole
nothing.
orders are, though in my, but this same have not been filed. If with the leave of
No, no,
the,
see,
if I
some
can,
one illegible order you have annexed here
Yes.
in page number 46.
Yes.
And first order, it was the first order. I think it was passed on. That is also not legible. Anyway, I don't know whether most probably give us some in the month of November 2020.
I may be allow Your Lordship to file
Just
the
file,
whole document.
file only
whole
order
orders.
sheets because, and this is also not here. The petition which you have filed seeking the medical ground is also not available here. You have
Yeah.
not annexed this.
Medical,
Petition which you have filed
yes, yeah,
seeking the medical on the medical ground. Is
I have
there
annexed.
it is available here?
Yes, annexure 2
In which page?
at page number 31.
Try to get some legible copies also, huh? Just file through an additional affidavit, you file the order sheets because there is no order sheets at all. Only the order, impugn order you have annexed, which
Yes,
is
Your
not
Lord.
at all legible.
But I
And
have
that
a,
apart, there are some hand corrections.
Mm.
This is not permissible. And after on 11/11/2020, one order was passed, and directly then the next order for your rejection was passed on in the year 2024, on the
Yes.
December month of December.
yes,
So the other issues are recorded. Why your petition was rejected? It cannot be.
yes, Your Lordship.
Just file it. Huh?
Yes,
You are Mr.
R. Rava, Rajamani Rava,
R.
Rava,
Your name is not reflected here.
Rajamani Rava. Yes, Your Lordship.
Hey, kiman number size? Do you number know? R. Abba 9.
No, Lordship. My name is not reflected in the course list.
For whom you are appearing?
Yes,
For whom
Vocal-
you are appearing?
appearing on
On
for
behalf
the
of whom?
petitioner, but I have the Okalatnama. I signed the Okalatnama.
But now your name is not,
Not
here. So
showing,
what
yes.
other
My
council
junior name is showing, M. Kashyap. Inago Kashyap.
M. Kashyap. Pardon, Mr. R. Rava appearing on behalf of Mr. M. Kashyap. After hearing the submission made by Mr. Rava and for his record, it is seen that they have not furnished the legible copy of the order sheets, and except 2 orders, there are no other orders are not available in the case record to come at a conclusion. In view of this, the petitioner is hereby directed to furnish the legible order sheets from 2020 to 2024 till the passing of the implement order through an additional affidavit. How many weeks you need? 2 weeks?
Yes.
But we cannot fix any date here. After 2 weeks?
Yes.
List the matter accordingly after 2 weeks, enabling the petitioner side to file their to file the additional affidavit to bring all the order sheets. In the same time, the registry is also hereby directed to reflect the name of Mr. R. Ravan in the cause list on the next. Your name will be reflected on the
Yes, yes.
You can
May it please your lordship. Your lordship, this case is not fit for mediation. Parties
Not
are
fit.
not, no, your lordship, parties are not willing to go for mediation, your lordship.
But what is the issue? It is only on
Lordship,
It's
kindly,
quantum, but parties are not agreed.
Lordship, kindly see the order dated 16 to 23. There is an order for direction for producing the original pension papers, and matter is in the hearing stage. So let the matter be listed for hearing in the last week of February. Order dated 16 to 23.
Yes, yes. But if it is only concerned with the enhancement of in regards to quantum,
Quantum.
Quantum, Lordship. So there is direction for producing the original pension paper.
Pension. Already heard, your lordship.
Part heard.
Part-
Let the matter be listed for hearing in the last week of February. We also filed crops objection here.
You also Goswami.
Be waterful.
Oh, sorry. Keyboard and and calculated and
1, 2, 3, Lordship.
that's one number 1, 2, 3. The case was identified for sending it to mediation, but it is submitted by the land council for both sides that matter has already been heard. And by order dated 16/2/2023, the respondent was also directed to produce the original pension paper and accordingly submitted that it may not be a case to send it for mediation. Considering the submission made by land council, the matter being listed for final hearing. We cannot fix a date. You want fixed date here? Fixed date
Fixed
is
date.
not possible.
In the last week of February, any day.
Fixed date is not
In the last week of February.
last week of February. Is the matter accordingly on the for hearing column on the last week of February. As an indeed to fix by the ministry. We're listing it out for final hearing.
Lordship.
Obliger.
Yes, here.
With the respondent, lordship, claimant mistake.
As per you, whether it is a fit case or not.
It is in fact, it can be sent. There was no dependency. The court gave a compensation of 40,000. That there was because the claimant was the nephew of the deceased, so dependency part was not there. But still, if they want, then because it is their call, lordship, their appeal, I won't object to it. But then, since they are not present, maybe they are not interested to go for mediation. I do not know. Can fix another date or
They
something
done
like
it. Once they know the non-application call for the applicant. However, RMS RD done in absence of the counsel for the applicant, the matter could not be sent for mediation. Otherwise, what was the stage of the case?
hearing, lordship.
Hearing.
Yes.
Is the matter accordingly in the hearing column. After 3 weeks, as an date to be registry. Okay, then we'll list.
And your May it please your lordship, Kindly matter may pass over for time being lordship. My senior election on the
No, it's time being, you are for whom?
I'm for the insurance.
Huh?
I'm for the applicant, lordship.
You are for the appellant.
Yes, lordship.
From whom? For whom you are appearing here?
National insurance.
Huh?
National insurance.
As a national insurance. Respondent side 9. Mediation কোথাও নি নুপুজে নি Now see, we are not going to pass any order here because the case was identified for sending it to mediation. That apart, there is nothing. So you are the insurance company, most probably due to absence of the other side, that the respondent side, we cannot send the petition for this. And I will record to hypersen. No, tolo. It's your hypersen. It's your You are MS?
P. Sutia.
MS P. Sutia appearing on behalf of Mr. D. You are appearing on behalf of whom?
D. Das Burman.
D. Das Burman, the learned counsel for the appellant. No one represented the respondent, though those services seems to be completed on the respondents. Due to absence of the learned counsel for the respondent, the matter could not be sent for mediation. The record of the TCR is also not received. Issue reminder, registry will do the needful. Let the matter be accordingly listed after 3 weeks as an edit to effect by the registry in admission. Listed.
Okay.
May I please, your lordship?
You are for whom?
Appellant lordship.
For the appellant.
Appellant lordship.
As per you, can it be, is it a case of for mediation?
It can be a lordship, but other
It
side
can be.
not appear.
So you are appearing for respondent numbers?
Lordship,
One.
appellant lordship.
Oh, sorry, you are for the appellant.
Appellant.
Service is completed or
Service
not?
is completed, lordship.
Completed.
LCR has been received, lordship. Matter takes for hearing, lordship. Matter can.
For one, most probably you have taken the justice service.
Justice service, lordship.
That has already come.
I have already
not
come.
filed your
And affidavit already filed.
affidavit file.
Affidavit already filed. And lordship, kindly see the order dated 17/11/25.
It is concerned with the respondent number 1. How many respondents are there as a whole?
2 respondent, lordship.
2.
2 respondent.
You are Mr.
AU Ahmed on behalf of K. Bhattacharya.
You are Mr. A.U. Ahmed.
AU Ahmed.
Or Mr. A. Ahmed. A.U. Ahmed appearing on behalf of Mr. K. Bhattacharya for the appellant. None appears on call for the respondent. So, the order dated 17/11 to 25. See that the service is already completed on the respondents. Here we have received CRs. Teacher has already been received. The matter was identified for sending it to mediation, but due to absence of the respondent, the matter could not be sent for mediation. List the matter accordingly on
on March, Lordship, March any date.
Sixteenth of March, when it's been admission.
I-
May please, your lordship. My lord, this is not fit for settlement, lordship. Okay. It's because, lordship, the driving license of the driver was, there was no actually driving license because he was having a driving license of LMV, not motorcycle. But at the time of accident, he was driving motorcycle, the driver of the
LMB
LMB means
the
four wheeler.
holder can also drive the
No,
motorcycle also.
not that way, lordship. LMB, it should be LMB category,
The
four
LMB
wheeler. But
category.
here is a two wheeler. It's a different.
But a person who has a suppose driving license of LMV,
Yes.
can he not fly the motorcycle?
No, lordship, not motorcycle. He can drive four wheeler, other category.
Other
Weight,
category, it's okay.
weight 7,500 up to 7,500 weight.
But he cannot
But
drive
he
a
can't
motorcycle.
drive two wheeler. He can't drive because that's a separate for motorcycle. Motorcycle driving license is separate. Two wheeler driving license is separate.
I can understand. A two-wheeler driving license holder cannot drive a four-wheeler.
No. Yes.
That is understood.
Yes. That
A
is
four-wheeler driving license who carries the four-wheeler driving license, he cannot
no
drive.
lordship. He is having the four wheeler and the auto rickshaw, that is three wheeler he is having. But two wheeler he does not have that big license. Since this is the point we have taken, lordship, can you hear the matter? And
But on 15/7/2020,
yes,
it was
lordship.
already sent.
Yes, lordship.
Then what had happened?
I
Thereafter?
think, lordship, they did not turn up. Today also they did not turn up because for taking steps, it took so much time, lordship, because we have taken paper publication. After that, they have appeared, lordship. Delay was there for 18 days delay. That was condoned, lordship. Then again, we have taken steps at the time of admission. Appeal was admitted, lordship. After that, their name is also shown in the cause list, lordship. Mr. F.A. Hassan. They are not appearing, lordship.
No, but on 15/7 order of 25,
yes,
most surely F.A. Hassan was present at the time.
It was sent. It was sent, I think.
It was sent for
It was
mediation.
sent.
On
It
the
was-
mediation, what had happened? Before mediation.
in his lordship, the,
Because now
I
see,
think
it is-
parties came, lordship, but it was not, I think, settled.
रिपोर्ट पे आए बुरी हालत ऑर्डर है नहीं नहीं पार्टी ज्वाइन no yet it says flag X flag X which was not settled. It was not settled.
It was not settled. Because of the pain recovery order was not there. That is why it was filed.
Forty-one to third MS M. Chaudhary, the learned counsel for the applicant. No one has represented the respondent number. No, none appears on call for the respondent. Though, from the record, it is seen that on 15/7/2025, Mr. F.A. Hassan appeared on behalf of the respondent, and the matter was also sent for mediation. But from the report submitted by the mediator, it is seen that the matter could not be amicably settled before mediation. It is also submitted by MS Chaudhary that it may not be a fit case for mediation as they raised the issue of having no valid driving license for the driver. In considering this submission made by MS Chaudhary, let the matter be accordingly listed. Otherwise, it is admitted. No?
Already admitted, maybe listed for order, lordship, because the regarding service of the owner is not
in
yet.
the order column. After 2 weeks, but we cannot fix a date here. After 2 weeks, as on a date 2 weeks. We have to
Stabilize
keep it. Item number 10. Nine. Then appear or fall for the petition. Estimated accordingly after 4 weeks. No, 3 weeks as a date, as on date 2 weeks by the registrar.
May please, your lordship. In this case, lordship, there is a direction to the petitioners to pay 1,000 while considering the interlocutory obligation, lordship. Lordship may kindly see the IA first, lordship. 868.
I-86. Order 99.
Yes, lordship, while the delay was condoned, 19,925. The last part, your lordship will find that there is a direction to pay 1,000, but it was not directed where to pay. So I have taken cash amount of rupees 1,000 if my learned friend accepts, lordship.
So now, where are you going to file now? 1,000.
Lordship, I have no instruction where to have. So if your lordship allows, I can.
They can even deposit in the registry.
Stay is better, I think.
There was no direction, lordship.
Direction was not.
Yes, lordship. We went to section and they said we have no such instruction to receive that amount. So we'll list this matter for admission hearing. At that point of time, you can take instruction from the court.
But on the
So-
basis of the said order, it has already been registered and numbered.
Yes,
Yes, lordship.
delay was condoned.
As we approach the section, we gave assurance that we'll deposit the amount and we'll deposit in front of the court, lordship. So later on, they have to withdraw that 1,000. It will better they will accept in cash, lordship.
But advocate,
Yeah, lordship may record that we have lordship submitted this 1,000 to the council for the respondents. So he can hand over it. to the-
The withdrawal part I'll do, my lord, let them deposit in the
before
registry.
registry, I think.
I'll
Lordship.
That is
That
their
part,
part. If they
lordship,
want
I'll
to withdraw,
deposit.
then they will withdraw because
Yes.
as an advocate, he may not be
Yes.
Lordship,
to accept the case.
lordship.
I mean, because in the trial court, it's okay
Yes.
because the parties are there,
Parties are-
so it can be directly punished to
Right.
them. But here to counsel
Right.
may not do that.
Lordship. And in regard to RFA, lordship, in this case, what happened? The petition appellant is a plaintiff, lordship. And I'm appearing for the appellant who is a plaintiff in the subsequent suit, which was filed against his own sister's sons, legal heirs, and that was, lordship, rejected on the ground that, dismissed on the ground that it is barred by res judicata, only on the point that earlier there was a suit, lordship, among both the parties that was decreed by the trial court, and when this present appellant filed title appeal, the decree was reversed, lordship. Challenging that title appeal, the respondent preferred a regular second appeal that is pending before this court, but they had not implemented this present appellant in the regular second appeal, lordship. So we have filed one IA for implement, and later on the advice of court also, we have withdrawn that IA, that they have not made you party. So it is not required to implement yourself in the regular second appeal. So that IA was withdrawn. But learned trial court said that as there is a litigation between both the parties, so this suit is barred by res judicata. But lordship, the prior portion of both the suits are different. For that, I have annexed the annexure 1, that is the trial judgment in the first suit, lordship.
So just tell us if basically in the original suit you were the plaintiff.
I am the defendant, lordship.
You were the defendant.
Defendant.
Achha.
My own sister filed the suit for claiming her share, lordship.
So in that degree, it was decreed.
Decreed. Then I preferred a title appeal, lordship. That is annexure 1, page 13. Your lordship kindly see.
Page 13, 1-3.
1-3, Lordship. Present appellant was defendant. He preferred this title appeal number 67/2013. So Lordship, kindly see page 14. This first appeal has been preferred by the principal defendant appellant on being dissatisfied with the judgment and decree dated 26/7/2013, passed by the learned Munsif number 1, Dhubri, in title suit number 337/2010, whereby the learned trial court decreed the suit on contest. So Lordship, this suit was
But why you were aggrieved? Because your sister claimed her share.
her share, Lordship.
Then why
So-
you were aggrieved?
Lordship, we denied her claim, Lordship, as we said that already share was given, so that suit was decreed, but first appellate court reversed that order, Lordship. Challenging this order, Lordship, they have preferred
Second appeal.
a second appeal.
So now in the second appeal, you are not the party.
No, Lordship. I was not made party by the defendant. In fact, Lordship, this is my title appeal. And they have challenged my judgment, which was delivered in my favor, Lordship, in favor of the defendant.
Why you have withdrawn your I?
Lordship, the court said that they have not made party. It is the duty of the appellant to make the parties, Lordship. So it is not necessary to implicate yourself in the.
Then in that case, what will again happen? Suppose you
Lordship.
are not the party. Suppose any reverse order is passed, so there may not be any order
Lordship.
against you. Suppose
Lordship.
because the title appeal order was reversed and that is in your favor.
Lordship.
But in second appeal, if it is
If the second
it is
appeal order reverse, Lordship, then my judgment will remain intact as because my part was not
your
challenged,
part was not challenged.
Lordship.
Uh,
On that
That
ground,
will be
Lordship,
on that ground.
it
yes.
was advised that you withdraw the.
But in that case, the second appeal, if it is second appeal is supposed thing decreed in favor of the appellant also,
Lordship.
they may face some problem
Yes, Lordship.
in,
they
in
will suffer.
executing the decree.
I have annexed the order passed
So
in
I
the
don't
regular
know.
second appeal also in this
But
regular.
yes, if you're not the party, then you have withdrawn yourself.
Lordship. Thereafter, Lordship, subsequent to that decree, Lordship, they have dispossessed me from my part of land, Lordship, the Masud land. So I have filed this annexure to page 30, Lordship. This title suit 26/2020.
Again, you have filed.
Yes, Lordship.
Oh, that is
Now
the
I am the
judicata.
now I am the plaintiff, and the legal heirs of that Rabea, my sister, are the defendants, Lordship. And my learned friend is representing them, Lordship.
Okay, now how many respondents are here now?
Thing is that since it is statutory appeal matter, so obviously it will be admitted,
it
notice will
it
go.
can be
And
admitted.
the thing is that I appeared because in the IA for delay condonation only I appeared, madam. That is why,
Oh,
so notice
otherwise
will-
you have not.
Yes, I have not even received a copy, so notice will have to be issued, madam.
Okay,
Okay, no
how,
problem.
as a whole, how many respondents are there? You are the only respondent here there?
No, my lord,
Government is there, Lordship.
Government is
other
also-
respondents as well, madam.
Other respondent, Lordship, in IA, I have already prayed for striking out the name of respondent number 12. So here also I will pray for the name, striking out the name of 12, and others already received notice and thereafter they
thing-
refuse to,
one
Lordship.
thing is that, if your lordship can do one thing, they can serve a copy of the memo to me. I can take instruction whether I can appear or not. Then that will be easy, madam.
Lordship, that
Or-
can be done, and Lordship,
or,
I am
one
praying
four.
before your Lordship to dispose of this appeal at the admission stage. There are some instances where RFA were disposed at the admission stage still.
No, it can
Lordship,
be, but now
Lordship.
it is.
Lordship on next
they-
date, Lordship, not
next date,
next
they may
date.
not be
As
possible.
because my suit was rejected, Lordship. In fact, Lordship, the prayer of both the suits are different. There she is claiming her share and recovery from me, and now I am claiming my right title interest and recovery from the legal heirs of my sisters, Lordship.
You are already been disposed.
Yes, Lordship, already with this. So the prayers in both the suits are completely different. The learned trial court committed a great mistake in deciding the cause of action and prayer of both the suits, Lordship. So my humble prayer, Lordship, a date may be fixed. In the meantime, I will serve the copy,
Now
Lordship.
here the 7 to 13, they are the pro forma.
Yes, Lordship.
So
And in-
otherwise you are appearing for one,
1
1 to 4, Lordship.
1, 2, 3, 4.
3, 4.
5, 6, 7,
5, 6 are the government.
government. And 12, I prayed for striking out the name as because Lordship, she died. During the pendency of the IA, the office note says that she died. Lordship. And others, Lordship, as per office note in interlocutory application, Lordship, they refuse to accept.
He can take instruction.
Yes, I'll take instruction. Then my lord, perhaps record will also be required, ma'am.
Record may not be required, Lordship, as because it was on law point, it was decided, and I have enclosed all the documents along with my regular first aid.
That's it. We'll keep it on call for the record. We'll keep it on for the admission column. If
Yes,
it can be heard
Lordship.
in absence in the non-availability of the record also in that case.
Lordship. As because the earlier suit records are already with regular second appeal, Lordship. And the present suit, there is no record. My plaint was rejected, Lordship.
Why your name is not here?
Lordship. My junior's name is there, Lordship.
I heard MS R. Chaudhary, the learned counsel for the applicant. But Mr. Esther, still learned counsel appearing for the response number 1, 2, 3, and 4. This is an appeal, section 96, read with order 41, rule 1, CPC. Challenging the order dated 22/03/2024, passed in TS number 26 of by learned civil judge senior division 3, dismissing the suit as not maintainable, being barred by the principles of inverted multiplicative risk. Is submitted by MS Chaudhary that by the time of following the delay in IA Civil 868/2025, the present appellant was directed to furnish rupees, directed to deposit rupees, directed to pay rupees 1,000, but there was no such direction for payment. But there is no such direction to whom the payment has to be made. In view of this, the learned in view of this, the appellant is hereby directed to deposit the cost of rupees 1,000 before the registry, and the respondent will be at liberty to withdraw the same in due course. Next part. Further, next part is submitted by Mr. Das that in the application, in the interlocutory application, he presented the response number 1, 3, and 4. But till now, he has no such instruction to represent the response, and accordingly, he submitted that copy of memo of appeal may be served to him so that he can take instructions from the respondents to represent them in the presence. In view of this, the appellant is hereby directed to serve the copy of the memo of appeal during the course of the day to the learned counsel bearing next part. MS Chaudhary further submitted it in the interlocutory during the pendency of the interlocutory application. The response number, pro forma respondent number 12 had already expired. And accordingly, her name was strike out from the cost title of the interlocutory application, and according
As per order dated 27/2/2025.
title of the as part order dated 27/2/2025. She made similar prayer for striking out the name of pro forma respondent number 12 from the cost title of the memo. In considering the submission made by her, the name of Momena Bibi, the pro forma respondent number 2, will be struck out from cost title. Next part, considering the submission made by the counsel for the appellant, the matter is admitted for hearing. Not like admitted, not like considering this so and so, let the matter be listed for. Now she is to take steps, or going to take instruction.
Within the course of the day, I will,
That will be provided, but you are
1 to 4,
representing
my
1,
lord.
2, 3, and 4.
1 to
For the
3.
other respondents, you are not representing.
No, no. 1 to
Issue notice. Issue notice to the other respondents, is namely 7, 8, 9, 10, 11, and 13.
Lordship,
Usual process you will do. take
Lordship,
steps.
for them, I will pray for striking out the name of the pro forma respondents.
All,
Lordship.
all.
Yes, Lordship, at the time of admission hearing, as because in IA also they have received not refused to.
So now this time I have already
Lordship,
strike out
they
the name
fixed
of
a
12.
date for admission
12?
hearing.
No, no. I'm striking out the name of 12.
Lordship.
So that prayer will be made before this court at the time of admission here.
Lordship.
Today may not be there because we are issuing notice.
Lordship.
Issue notice for the That's what. Yes, Mr. Butler said who are appearing for 7, 5, and 6.
I can appear for today because they have not served the pieces.
Lordship, after condonation, today is the first date, so I have
This is
not.
It's not necessary to. Let them serve in the office of the
This we also serve to the respondent number 5 and 6. The government respondent number 5 and 6. We may not be in a position to fix a date. So after 2 weeks or 3 weeks, will we do?
Lordship, your Lordship is issuing notice, so I have to take step on the pro forma respondent.
Yes.
Then it will come after 4 weeks, Lordship. So for that only, I am praying that no need to issue notice. Your Lordship may fix a date on.
That's how they have already, they are the party here. So on the next date, you may make your submission, and on that very day, we may strike out the name.
Lordship. Then
So now
speed
12
post-
we have already struck out.
Lordship.
1 to 4 I have already reflected the name of Mr. Das.
5, 6,
And 5, 6 they will issue notice and comment will appear accordingly.
Lordship.
Just
The
provide.
others I will take step speed post, Lordship.
Your choice is either was you can take speed post or an usual process.
Lordship.
So we're listing it after 3 weeks will do.
Lordship, 3 weeks.
But date may not be fixed. In that case,
we showed the causeless also. It's not a going with the causeless also government.
In condonation, they were there, Lordship. So their name shown in the
Yes.
Lordship.
so you are going to appear or what? You are saying that you are not going to appear.
No, they. I mean, next time.
Registry may be directed to show the name of
That
government.
can be done. Just try to
Lordship may give a date in this case my name has not been.
In that case, it will be on 9th of March.
Lordship.
9.
Oblige.
You take instruction, Mr. Das.
My lord, I'll take it.
Oblige.
Highly obliged.
Your Lordship, I'm very sorry to make a mention, Your Lordship. In item 10, I'm appearing as the petitioner there. I was in another court. By the time I reached, the item 10 has been passed.
No, any other adverse order is passed. Only
Only then-
we are
then-
listing it after 3 weeks.
Lordship may fix it for next week for hearing. Otherwise, the matter is ready for hearing. Or
No, we are not passing. Your absence is already recorded.
Lordship,
So
there's a
we are
interim
listing it after 3 weeks. Let it be after 1 week. Okay.
1 week and the interim order will continue. There is a stay of the
Okay, 1 week for it, interim week. Okay, we are
interim to continue. Oblige. I apologize.
1 week, interim week.
Oblige.
May I have your lordship? Kindly pass over the matter for time being. The senior is in court number 8 conducting a hearing.
You're for the
time being.
respondent.
Respondent.
Okay.
May it please your lordship. My lord, this is a regular first appeal, my lord. Statutory appeal, my lord. If your lordship will kindly see the impugned judgment at page number 58. The appellant was a plaintiff, my lord, and the defendant, my lord, also filed a counterclaim. So, plaintiff suit was dismissed, and the defendant's counterclaim.
You were the plaintiff.
I am the plaintiff. The defendant's counterclaim was allowed. So, my lord, we have preferred two appeals, my lord. One against the counterclaim and one against the dismissal of the suit, my lord. This is against the counterclaim, my lord. So, my lord, this may be admitted, my lord, and in the interim, my lord,
So where is the other appeal?
appeal is registered, my lord, but has not come
Not
to payment.
listed.
Yes.
Whether it is numbered, not
Yes, numbered also.
numbered.
Numbered also.
You just tell us the number.
Well, I'll give it to the provided to the court
Okay.
first.
Part Mr. Esther, Silent Counsel for the appellate. It's an appeal under order 41, rule 1, related with section 96 APC against the judgment and decree dated 15/6/2024, passed by learned civil judge senior division Kolkata, entitled suit number 54 of 2014, decreeing the counterclaim. Oh no, this is for a decreeing counterclaim.
Yes.
Your dismissal is not this one. This is what
Not
this is
the dismissal of the suit. Counter.
decreeing the counterclaim of the respondent. Appeal being a statutory appeal, same is admitted. Issue notice to all the respondents to be post and usual process. Also call for the PC. Further, it is submitted by Mr. Das that they have also preferred another appeal for against the order of dismissal of their title suit. Dismissal of the title suit, wherein they were the plaintiff. Post. In view of this, let the said appeal, which has already been numbered and registered, be tagged along with the present. List the matter accordingly. 4 weeks as on a date. You text it, we are also calling for the case report.
Yes, and my lord, in the IA, my lord, till the next date, my lord, the operation of this order may be still.
It is a stay petition.
Yes, I.
I Mr. Esther, and it counts for the applicant appellate. This is an appeal. No, sorry. This is the interlocutory application been filed for paying for stay of the execution of the decree dated 15/6/2024, passed by learned civil judge senior division Kolkata, entitled suit number 54 of 2020, decreeing the counterclaim of the respondents' defendants. It is submitted, Mr. Das, that they have already preferred the appeal against the order of against the judgment and order passed by the learned, and they have already preferred 2 appeals against the judgment and decree dated 15/6/2024, passed by the learned civil judge senior division Kolkata, entitled number 54 of 2014, decreeing the counterclaim and the dismissal and for the dismissal of the case of the present for the present appellate. Considering the submission made by Swens, let the execution of the decree dated Swens be stayed till the disposal of the connected party. With the above observation, present I stand.
Well, highly obliged.
There was a VC request. In 15.
That's my briefing counsel, my lord.
My lord, we are being led by the senior advocate, my lord. We are also for the petitioners, but leading counsel is senior advocate in this matter.
What do you have said?
My lord, we also for the petitioners in this case, the leading counsel is the senior advocate, R. Sharma.
I'm R. Sharma, my lord. He's my briefing
No,
counsel.
you are
except-
acha,
My
okay.
lord.
Now he is there to someone will inform us that the council will be on the through VC. That's why I thought that you.
My lord, he's my.
Okay then. Okay.
My lord, this petition was filed under section 2, under article 227. My lord, this is against the order of the learned district judge, who has passed an order under which is outside the purview of the jurisdiction of the learned district judge. Because, my lord, at page 18, my lord, if my lord comes to page 18 of my petition,
1-8.
1-8, my lord. This is para 20.
Yes.
If I may read it, that a petitioner respectfully submits that in the construction of the so-and-so transmission line on the Silchar BPK Bari transmission system, the Power Grid Corporation of India exercised its power under Chapter 3 of the Indian Telegraph Act 1885. The compensation was determined and paid in accordance with Section 10D of the said Act for damages caused. Therefore, any grievance regarding the compensation paid under Section 10 of the Indian Telegraph Act 1885 can be addressed by the affected landowner by seeking redress under Section 16 of the Act. It is specifically provided under Section 16 that the jurisdiction to determine such compensation vests exclusively with the district judge. Section 16 of the Indian Telegraph Act 1885 is reproduced herein below. My lord, may kindly come to page 19, subsection 3 of Section 16, my lord. If any dispute arises concerning the sufficiency of compensation to be paid under Section 10, clause each shall on application for the purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated may be determined by him. Now, my lord, this order was passed by the learned civil justice senior division, my lord, and learned civil justice senior division had no authority. It is a case of patent lack of inherent jurisdiction. So, my lord, the other side had appeared the last
Filed by the learned civil justice senior division.
My lord.
Which district?
My lord, this is Karimganj in title suit number 71 of 2022. My lord, with all respect, my lord, this matter will need some hearing. So my lord may fix a date, and other parties have also appeared if they wish to file their counter within that period of time.
So my lord, only issue is the jurisdiction. That is the
jurisdiction.
Now, whether this civil division is maintainable, that is also a question. Because it is against decree. Against that decree under Section 94 CPC, appeal lies. So far, that is only on question of jurisdiction.
Question of jurisdiction, my lord, we have an alternative remedy, but here the case we have come under 227 directly because it's apparent on the face of the record. It's a patent lack of inherent jurisdiction, my lord. In that case, my lord, a writ court can pass necessary orders. So I'll place the necessary judgments before your lord, my lord, whenever my lord fixes a date.
Any
Want to fix it in the admission column itself or
admission column or any Tuesday or Thursday?
Tuesday or Thursday.
Tuesday or
It will take some time.
On page number 3, my lord, there is some confusion in this because I had already heard that about 50 cases disposed of and the CLPS. What is there? This is half of the part of the operation, the line being within the road that they have to lay all
connected.
One area to another area. So later on, it has come to the knowledge of the parties that at certain stages, NIPCO has executed the projects, and there is some confusion. It is not clarity there. And last time, a few cases, they tried to again come back from the lower court. It was sent back to lower court to clarify that. But then also it did not, nothing happened. They could not proceed further. And then they came for further orders to the High Court. And that was also dismissed because there was some delay in that process the High Court had asked them to do in the lower court. So that the High Court dismissed. So now the NIPCO is a party. They better clarify which part was done by NIPCO and which by Power Grid, my lord. Otherwise, there is confusion later on and unnecessary delay.
Otherwise, you are the government respondent.
Yes.
So you are appearing for 4?
Yeah, I am appearing for 4, 5, 6, 7.
4, 5, 6, 7.
My lord, with all respect, my lord, this is a total different batch of writ petitions. This is regarding this writ petitions my learned friend is mentioning about has been already passed by the district judge. Now the issue is about compensation, whether the proper procedure is followed. That is also under 227 because no remedy for alternative remedy has been provided. These writ petitions are totally different. It has been decided by the learned district judge Hailakandi. So what my learned my friend is mentioning is a different batch.
No, that may be, but
Here, my lord, the issue is solely on jurisdiction, whether the learned civil judge senior division had the jurisdiction to entertain this matter.
Oh.
So my lord, the fixed date may be fixed after they filed.
I'm appearing 4, 5, 6, and 7.
Are Mr. Arsham, the learned senior advocate, assisted by Mr. T. Mangar,
Margar.
assisted by Mr. T. Margar, M-A-R-G-M-A-R-N-G-A-R, Margar. And also heard Mr. Anhop, the learned counsel, appearing for respondent number 1 and 2. 1 and 2. And Mr. K. Vadasaji. And thus, the appearing for the respondent number 3. And Mr. K. Vadasaji, the learned government advocate, appearing for the state respondents number 4, 5, 6, and 7. It is submitted by Mr. Sharma, the senior advocate, that there are some law points to be determined in regards to the jurisdictional authority, the learned civil judge senior division, who had passed the order. And in the same time, it is also submitted by Mr. Hawk that they also going to submit the objection, their affidavit in opposition, just claiming that the present petition itself may not be maintainable. In view of this, the respondents are hereby asked to file their affidavit, counter affidavit, if any, on or before the next date of listing. That the matter may be listed for admission hearing, on which date the endeavor shall be made to dispose of the matter. You want how many weeks, Mr. Hawk?
My lord, we will not file any affidavit.
You're not going to file.
should not
Look at it, if any only you have written, in that case, it will be again listed in the admission column.
My lord,
No,
on
12 is
20
almost full.
my lord, 24th of February,
24 can be 24th.
Tuesday, my
Okay.
my interim orders pass earlier may continue.
24. Interim order be continued till next. But compensation is already disbursed here in this case.
No, my lord, because of the time, because of the title, because of the stay.
Execution is
Execution.
No, the initial payments has been made, man. The payments that were earlier awarded, the enhancement has not been
in this.
Not in.
Not here in this case.
No,
There's
not
a
in
set of cases, I think, bunch of cases.
Those are-
There
those are
in
different
some
batches-
cases,
batches of-
there are enhancement of compensation matter is also there, and there are some others. This may not be of that
No, no,
batch.
this is only a sole issue of jurisdiction.
Oh.
Obliged.
Obliged, my lord.
May it please the lordship. Lordship, this is an appeal under section 9 of the Family Courts Act, my lord. My lord, the petitioner is a doctor by profession and the respondent of
Just a second, where is the respondent here?
My lord?
Because Mr. T. Bhargaviari or and Jed Hawk name is here. They have appeared or they have not appeared?
Earlier, there was a delay continuation petition wherein they
That is
appeared, my
already
lord.
disposed of?
That has been disposed of and there was a direction to register this appeal.
There they have already appeared.
They appeared, my lord.
How many respondents are here as a whole?
Sole respondent, my lord, the
Sole
respondent wife only.
But now too, you have to again send the, that is the procedure.
Lordship.
But most probably they may appear, or you could have informed the counsel for the other side who already appeared. Now, in one case, we have done this one. There's the memo of appeal was asked to serve, and he may take instruction in that regard. But here too, two names are there, but they are not appearing
Lordship.
today. Anyway, what is your case?
Lordship. Lordship, the petitioner is a doctor by profession and the wife is also a working lady. She is working in grade 4 post under the state government. My lord, they got married in the year 2020 and they are blessed with a girl child in April 2023, my lord. My lord, after the birth of a child, the wife is residing in the paternal home, my lord. And thereafter, she is not visiting the husband's home. And she has not allowed, the wife is not allowing the father to meet with the child. And the child is being taken care of by an untrained maid, lordship, since she is working lady.
But the girl child is still with the husband.
No, girl child is with the mother, my lord. To that effect, Lordship, a custody case is filed before the Family Court Dhuburi, my lord, and that case has been rejected because child is very minor, my lord, almost 3 years as of now. But there in the rejection order, a visitation right was granted. That may be kindly seen by this honorable court. Page 28, the last paragraph, page 28. May I read? Very small paragraph, my lord. The court is of opinion that there is no requirement of interference with the custody of the child. Thus, the instant petition of the petitioner seeking custody of the child is rejected. However, the petitioner is granted visitation rights to meet his daughter twice in a week, 3 hours during holidays or after working hours of the opposite party, as at any suitable place agreed by the parties, my lord. My lord, since visitation right is there, lordship, I have tried to visit my child, lordship, several times. Even after having this order, she denied my visitation. And the situation is too pathetic, my lord. The girl child who is of 3 years old, she unable to recognize the father because father is not allowed to meet. So at this stage, my lord, the lower court record may be called for. And minor observation, lordship, may I pray that till the pendency of this case, lordship, the visitation right as granted by the family court may be continue, my lord. That much, lordship, I am praying at this stage.
Now, see, the question is that your visitation right is already there.
Already there, my lord.
So you have come with a petition as because she is not allowing you to meet.
My
Isn't it? So it is already there. The
It is already-
visitation right, the order is already standing. It's not a case that it has been reversed by any court.
My
So that is only there, but you have come before. Let us do one thing. It may be taken up the matter in the chamber itself. We may ask the party come before this court also. It can be amicably. It may arrive the decision also because it is a very sensitive issue.
My lord, my lord. It can be
and
done.
you have submitted that in the girl child is not even recognizing her father.
My
That
lord.
is also very
My lord, what has happened, even the mother tried to change the father's name in the birth record. It is only after the interference of the officials of the health department and the deputy commissioner lordship, this act has been stopped by the mother. So mother is trying to alienate the child from the father. So whatever order passed by this honorable court, that will be followed, lordship. But till the pendency, lordship, the visitation right may be continued.
no. It is already continued.
Lordship, lordship.
Oh.
If this observation is there, it will be helpful.
Not rejected by any court.
My lord, my lord.
You are Mr. Mandal.
I am R. Karim, my lord. My
R.
name is
Karim.
R. Karim, my lord.
Your name is not here.
My lord, I have signed in the Wakalatnama, but I do
Anyway,
not.
I'll record your name.
not
Mr.
sure.
R. Karim, the learned counsel for the appellate. Then appears on call for the respondent to the names of 2 advocates are being reflected in the cost. Post. And from the submission made by learned counsel for the appellant, it is seen that the advocates, the counsels have already appeared at the time of disposal of the interlocutory application for condonation. Post. Next part. This is an appeal on Section 47 of the Guardians and Wards Act 1890. So now you are not supposed to challenge the order of so and so. So
Lordship,
what
since
is your
custody was denied, I have challenged it, lordship, because some issues I am not expressing before this honorable
no,
court.
no, I'm not on that. And highly, I don't know why highly aggrieved and dissatisfied means what?
My lord.
Yeah, you are saying
My lord,
rejected the petition of the appellant. Your petition was rejected.
It was rejected. Visitation right is given, and that petition was proceeded ex parte, lordship.
Now you are against that order, your rejection order.
I am against the rejection order, my lord.
Oh, now you are against the rejection order.
I am against the rejection order.
Against the order dated 2709/2020, passed in FC, Miss bracket of G, case number 03 of by learned principal Judge Family Court Dhubri, rejecting the petition for the of the appellant seeking custody of the child. However, the visitation right was granted to the present appellant. But in spite of this visitation right, the respondent is not allowing to meet the child, and for which only the present present application has to be filed. Present appeal has to be reviewed by the appellant. Next, during the submission, the file and counsel for the appellant matter is admitted. Issue notice to the sole respondents through speed post and usual process. Usual process. Or thank for radio conference of the. I'm just giving one line only, but that much I don't know how much will help you.
My lord.
From the on perusal of the impugned order dated 27/09/24, it is seen that admittedly the appellant was given the visiting right, and the accordingly the court directed accordingly. Directed the respondent to meet. No, accordingly, the court gave the right visiting right to meet the to meet his daughter twice in a week for 3 hours during holidays or after working hours of the respondent. Again, লিখিত হইতো বা লিখতো না notice করে admit করে দিও. We are listing it. Yes, after 2 weeks, 3 weeks we'll do. In that case, we are not going to fix any date. If you want fix any date, we are not going to fix. Date is not fixing. And let them appear. We'll call the both the husband and the wife to my chamber and we'll talk.
My lord.
And in the meantime, you again try. What happens? See, let's see.
I will be trying, my lord.
You try, just try. Because after this order, I mean, receiving notice, there may be some reaction to that regard. So let us see.
Let us. My lord, can it be after 3 weeks? If not,
we are listing it after 3 weeks, but we are not giving you any fixed date.
Problem, my lord.
After 3 weeks. Oh, sorry. The name of Mr. R. Karim may be reflected in the context. Admissions.
I'm for the petitioner. As per office note dated 21/26, additional notice upon 345 is come.
You are appealing for whom?
Respondent number 2, 61, 62, and 63.
2, 61?
62 and 63.
So basically 2 and 6.
Yes.
Who is 1?
I'm for the petitioner.
No,
One.
who is 1? 1.
One.
Respondent number 1?
Respondent number 1 is Arpana Das.
So as per the office note of 2101, 26, the notices on respondent number 3 to 5 are being served. And but the registered post return answer, however, through process server, it is served. It
Yes.
seems to be served. And but where is the one? Is there services also completed on one? Do you have any information? One.
One actually earlier engaged by other advocate. I have been newly engaged.
Mhm.
One is already on record.
Past. জানিব লাগিব এক নম্বৰ জন কি It was also seems to be served. One. One, two. You are Mr.
T Roy. Actually, order dated 24/1/20.
20,
Order dated 24/1/2020.
24-1.
Petition has been directed to the steps about 3, 4, and 5. Throw respondent number 1. 24/1/20.
Now they received it. So services seems to be completed. You are Mr. Roy? T. Roy?
Yes, T Roy.
Hi, Mr. T. Roy. Counsel for- And also her MS. You named MS?
S. Das.
S. Das.
On behalf of Mr. F. A. Barbia.
S. Das appearing on behalf of Mr. F. Borbia for the respondent number 2, 6.1, 6.2, and 6.3. Point no as 61, 62, 63. Further from the office note, it reveals that the service is also and notices are also being served to the respondent number 3 and 5 and through the usual process. Does it seem that the service is already completed for all the responses? We have received the scan copy. A copy is in this year. LCR has already been received. In that case, we can list the matter in admission column. Admission hearing column, we can list it matter. In view of this, they let the matter be listed in admission column after 3 weeks, as on a date to be by the registry. Is there any interim? No.
Interim
Was
is
there
not-
any interim?
Yes.
On the last
Interim-
occasion, interim order was not completed, Lordship.
It is not
16, 12,
continuing.
16,
Lordship.
16, 12, 16.
No, but it is not continuing.
Yes.
It's not continuing. If you need, then you have to find another IA, but at present it is not continuing. So we are listing it after 3 weeks in admission column. We'll see to it.
Please, Lordship.
As per office note dated 27/1/26, TCR has been received and answer notice against the respondent amount due to insufficient address. Lordship, today
It's
morning,
there received.
the applicant has informed about the new address of the respondent number 1, Jyoti Borgohai. Kindly we maybe take to fresh step upon the respondent number 1 on the new address.
And this is for one, and how about what about the other respondent? Is there any other respondent? Only
Yes.
one.
Two respondents. Performer respondent. He filed their wakalatnama.
Whom I have already. You are Mr.
L. Thakuria for S. Sharma.
Part Mr. N. Thakuria appearing on behalf of Mr. Esha, Internet Council for the appellate. For office note dated 27/01/2026. The notice issued to the respondent number 1 returned unserved with a note inverted comma insufficient address returned to the sender. However, it is submitted by Mr. that they have already procured the new and present address of the respondent number 1. Accordingly, he may be allowed to take fresh steps on the respondent number 1 in his new and present address. Where allowed, the petitioner appellant will accordingly take steps to issue notice to the respondent number 1 in his present public new address to speed first on India process. Yes, TCR has already been received. Let the matter be accordingly listed. After, you may need 3 weeks, I think. After 3 weeks, I will need you. I have already passed the order that in the new address you can take steps.
I'll look.
Wait, this is your Lordship. Lordship, this is ready regarding service and everything. And LCR is also received. So Lordship, it can be fixed for final hearing. Any date, Lordship?
A date may be fixed, Lordship.
Part Mr. RMS Adimuchum done for the event, and also part AU Ahmed.
AU Ahmed, Lordship, on behalf of Cable Tech.
To give the such services covered. And here the TCR we have received, no?
Yes, Lord.
TCR has already been received.
Office note 17/8/22 itself, Lordship. Long back it was.
Long back. And there were how many respondents are there? Only one. Sole
Two, Lordship.
Two. You have appealed
Served,
for
Lordship.
No, Lordship, I'm appealing for one.
Lordship,
And what about-
Lordship will peruse office note dated 17/8/22, where it is mentioned LCR received, Wakalatnama by respondent 1, and 2, Lordship, process server notice received, flag X.
It has already been served.
Yes, Lord.
The TCR has already been received. Let the matter be accordingly listed for final hearing. You want a fixed date here?
Yes, Lord.
And in that case, it will be on 24th of March.
Fine, Lord.
Lordship.
Highly obliged.
Oh, अच्छा, अच्छा, that case, huh?
Appeal was not admitted it.
So, here only sole respondent is here. You have not taken steps, I think. You are SR Gogoi, na?
Yes.
Heard MS SR Gogoi. Done it.
Lordship, I am B. Dutta on behalf of SR Group.
Sorry, I heard MS Peter. Appearing on behalf of Mr. SR Gogoi. Appearing on behalf of Mr. SR Gogoi. Submitted that Mr. SR Gogoi has already been newly engaged in the present case. And they have also received, NOC from the earlier this country, Mr. G.G. Gogoi. This is an appeal. Appeal under Section 96. And under Order 41, Rule 1 and Section 96 CPC against the impute judgment and decree dated 4/5/2022 passed in title suit number 03 of 2022 by learned civil judge Hemaji, dismissing the suit of the present plaintiff and declaring the counterclaim of the defendant. Appeal submitted issue notice to the sole respondent through speed post and usual process for the PC. With the matter be accordingly listed 4 weeks as on a date to be filled by the registry. Further, registry is hereby directed to reflect the name of Mr. SR Gogoi and MS Bidar in the cost list. The next step. Okay. To take steps for the response.
Wait, please, your lordship. Lordship may grant 2 days time to take fresh steps.
Fresh steps.
In this case, for purpose and for the all the respondents except respondent 5. Steps for respondent 5.
Okay.
So you are appealing for all the respondents?
Except respondent 5. And my learned friend might have prayed for taking step for respondent number 5.
So it was 5-1, 5-2, 5-3.
Legal errors.
Achha. Your MS?
S. Ajmi.
S?
Ajmi.
Ajmer.
Ajmi. AJMI.
Azmi.
MS S. Ajmi. Your name is not you appearing for MS R. Chaudhary?
Yes.
Yes.
Application behalf of MS R. Chaudhary, the learned counsel for the app. And also heard Mr. P. Dekar, the learned counsel appearing for the respond number 1, 2, 3, 4, and 6. 4 and 6. However, it is submitted by MS Azmi that inadvertently they could not take steps. The newly implemented respondents, that is respond number 5.1, 5.2, and 5.3 in their present addresses. Say accordingly, please take fresh steps on the response. Number 5.1, 5.2, prayer allowed. Let the fresh steps be taken. If there's the issue, fresh notice be issued to the respondents. Number 5.1, 5.2, 5.3 in their present address. Through speed post and as usual process. List the matter accordingly. After 4 weeks, we'll do.
I not my one prayer, my lord. My in the respondent column, my lord, my other colleagues' names also there in the color number, my lord. So, my lord, the rest is directed to show the names of the respondents' counsel, my lord.
And so further, considering the submission made by Mr. Dekar, the registry is hereby directed to reflect the name of the other councils which is also represented in response.
Deeply obliged.
Obliged.
Wait, please, it's a loss in my service is awaited, my lord. Office note, my lord, 2/2/2026, my lord, reflected.
It is awaited.
My lord.
Sole respondent is here only.
My lord.
You are Mr.
HP Gwala, my lord.
Part Mr. H.P. Gwala, Internet Counsel for the petition. From the office note dated 2/02/02/2026. This seen that neither the ID card nor unserved notice have returned, which was issued to the sole respondents. Let the service be abated till next date of listing. Listing matter accordingly. We are listing it immediately after 2 weeks.
My lord.
Weeks as on a date we by the registry.
Obliged.
This time we are awaiting this service. You just try to collect if there is any other.
Yes. Obliged.
26.
May it please your lordship. In this case, service regarding respondent 1 is already appearing, lordship. Regarding respondent number 2, 3, already service is complete.
1 is appearing, 2, 3 is completed,
Yes, your lordship.
and 4 is awaited.
4, we have filed an affidavit, a dusty affidavit, which he refused to accept, lordship.
Refused to accept.
Yes, lord.
Where is your affidavit?
Affidavit at flag A, lordship. In para number 2 we have given the details.
That is only your telephonic conversation.
Telephonic also, lordship, the deponent went personally in their office.
That's what I'm saying. The
Yes,
opponent
Lord.
went personally to his office.
Yes.
He was not present.
It's not
So
present.
he somehow corrected the contact number and then he contact with the switch.
Yes, sir.
And as per your hearing after, he will not receive such copy.
Yes.
But it is not a case that he was physically present and personally he refused. It is only the telephonic conversation.
Yes.
That's saying.
In this case,
Otherwise, how you are related with the other respondents? Respondent number 4.
Lordship, we are not related to respondent number 4.
Not related.
We are appearing only for respondent number 1.
And you are for 2 and 3.
Only 1.
2 and
You are
3.
for 1.
Service
You
is
already
complete.
served.
Yes, lordship. Service is complete, but
Or is
till date they were not
Srimati
appeared.
Geeta Mal. She is wife of one late Santi Ranjan Sen. She works in a railway department or what?
Lordship, he doesn't work, but her son used to work. She already
Son?
left. Yes, lordship. We have collected a new address from our petitioner, lordship. Then after that, we came to know that she used to stay with her son.
So, but the new address, her new address is a different address.
Yes, lordship. In that also we have taken registered step, but no fruitful result came, lordship. Therefore, we decided to take dusty steps.
Wait, 2, 3, and 4 are the pro forma.
Yes, lordship.
All are 2, 3, and 4 are the pro forma respondents. Right? As per your application. One is the respondent plaintiff, and the others are the pro forma respondents.
Yes.
You have cited them with the performance.
Okay. Lordship, can it be deemed to be served?
What I'm on that there's no personal communication. It was through only through telephonic conversation. That is the only thing I just because the refusal should be the personal refusal. When physically or personally, if he or he is present, then he or she may refuse that I'm not going to accept. That is the in fact that is the law. That is the we can think is a refusal and can be deemed as a service. But here too, I don't think that is there because she was not there. She was not present at that time. Try to give another not true testimony because it may not be accepted. Or if you think that as she is a performer respondent, her name may be deleted, that can also be done, but it will be on your own risk.
Lordship, can it be heard after some time? Lord?
No, otherwise you take steps.
Steps
You
to-
take instruction. If her name can be deleted, then it can.
Lordship,
You can instruct.
later I will take instruction.
The case is here. Okay, we'll take it after some time.
Lord,
After some.
oblige.
Lordship, very sorry to say, Lordship, in item number 22, I forget to submit before you. There is a IA petition for staying the execution degree.
Sorry, it will be listed underneath.
May I please, Your Lordship? So the service upon the sole respondent has completed and LCR has also come. The matter may fix for admission.
They have already appeared.
May fix a date, Lord. Fix date.
Sole respondent was
Yes,
there.
Lord. Date may be fixed.
Part Mr. G. Kalita, done it on the petitioner. But your good name.
Borua, on behalf
M.
of
Borua, appearing on behalf of Mr. Airshire. Yeah, done it counsel for the sole respondent. Services already completed. Hey, we have received the case. ECA has already been received. Let the matter be accordingly listed in the admission hearing on
In the month of February, last part of February.
it will be on 17th of March.
17th of March. सारा कुछ नहीं.
Last week is almost closed. We can fix it on last week of February, but without mentioning the date. In that case, it can be done
17th of February.
because it may be adjusted in that regard. Otherwise, last week of 17th of March. This record.
Apply.
May I please, Lordship? Lordship, in this case, Lordship, respondent number, Lordship, as per expired, Lordship.
Expired.
Lordship,
Which
and,
respondent?
from my plan, Lordship, I have instruction that in appellate court, lower appellate court, Lordship, legal heirs of respondent one, Lordship, substituted, Lordship. So I may be,
Substituted.
yes, Lordship. So I may be allowed to file a two-page application before the National Court, impleading them legal heirs of the respondent one as the party respondent.
Respondent number one.
One, Lordship. One,
No, one.
one
you
A,
want
Lordship.
there.
One A.
Who
Atikur
died?
Rahman,
One A died.
yes.
Acha.
Atikur Rahman Borbuya. Legal heirs already, Lordship, impleaded, Lordship, in court below, Lordship. Recently, Lordship.
You
And
can
so
collect
far,
the name and addresses there.
Lordship,
You can collect the name and addresses from your court below.
Lordship. And I will file, Lordship, a appropriate application for impleted, Lordship. Implement, Lordship, already they are in party in the appellate. So far as, Lordship, respondent number one J, Lordship.
One J.
Lordship. My learned friend will, Lordship, take instruction.
One J, you are appearing.
1J
Expired, Lordship.
respondent number 4 and respondent number 5 expired, your Lordship. 1J
1J is also expired.
Yes.
expired. 4 also expired.
4
5 also
expired,
expired.
and 5.
5.
6 also expired, Lordship.
6 also expired.
Yes, so we died unmarried, Lordship. So
May not be any legal.
name may be stuck off, Lordship.
His name may be stuck.
The 1J 4 and 5 Lord, and take instruction whether they have legal heirs or not. I have put the
You have to take instructions. And otherwise, you are representing whom?
rest of the 5
Other
rest-
respondent.
other respondent.
You are Mr.
Bimalakar, Lordship.
Bhima. Heart, Mr. Bhima. And you are Mr. Laskar.
Lordship. MH
Heart, MS, MH Laskar for the response. It is submitted by Mr. Malakar that it is done from the it is done that during the pendency of the present case, respondent number 1A died, and the legal heirs of the respondent number 1A are already substituted in the by the learned appellate court, and hence he need some more time to file the interlocutory application for substitution of the legal heirs of respondent number 1A, and also to collect the name and addresses of the same. Next part. Further, it is submitted by Mr. Laskar that the respondent number 1J, 4 and 5, 4, 5 and 6 also expired during the pendency of this. However, he needs some time to take instructions in regards to name and addresses of it to take instruction as to whether these respondents have any legal heirs to be implemented. Next part, Mr. Malakar further submitted that as per his information, the respondent number 6 was unmarried, and hence there is none to be implemented as a legal heirs for the respondent number 6, and accordingly he prayed to strike out the name of the respondent number 6 from the post title of the NB office. The registry will do the needful in striking out the name of respondent number 6 from the post title of presentation. List the matter accordingly. You need some more time, I think 3 weeks, 4 weeks. We cannot fix any date here.
one date may be given after 4 weeks.
Okay, so civil case or date দিব লাগে একটু টাইম
Last week of March, Lordship, any date?
27th of March.
Obliged.
May I please, Your Lordship? My lord, in this matter, as per official dated 2/2/25, that reflects the official dated 8/9/25, that the address is not found, the respondent number 2. My lord, so we have taken step as per the address available in the plane. So we may allow to paper publication, otherwise we have no other address.
So respondent number
Number 2, Your Lordship.
2.
This address is available in the plane for the respondent 2. So we may be allowed for paper publication, otherwise as per 8/9, there is no such person, or it is a company, builders company, Messrs. JB Builders
It was a farm or what?
Farm.
Lordship, I am
As
appearing.
per information, yes.
I am for one.
One.
Respondent number 1. Individual. I was the plaintiff at the suit. Argument stage has been deferred by the learned trial court in view of the pendency of this revision petition, and at the same time the argument is deferred initially also. So a short date may be given, Lordship.
But in the learned trial court below, whether the defendant number 2 or the said farm is appearing there?
Actually, the in ex parte decision was there against them. They are the building firm, actually, builder's firm.
So
Expiry.
in the trial court also.
They did not contest the suit also.
He has not appeared, madam.
They did not appear from the very beginning. A suit itself is belong to the year 2012. It is almost now 13 years old suit here. Thereafter, another options, legal option also there for revision, appeal like this. So short date may be given, directing them to take steps within 2 weeks or 3 weeks like that. Whatever steps they take actually, as per their wish. It may be the newspaper steps. Since February 2024, agreement has been deferred. Almost at final stage. Hearing of both sides has been completed. Almost argument remained.
But madam, the case is fixed for argument without cross-examination of defendant, but DW 2 and 3. There are also
That's
two.
why you have come.
Actually, they did not appear before the learned commissioners. Now it is the cross-examination is entrusted to the commissioners. They did not appear at the right time. They took one after another dates. Number of dates they had taken before the learned trial.
This is not correct, my lord. Immediately after the close of the DW1, we had filed a petition for re-examination of DW1. Along with the order of the re-examination, rejection of re-examination, the case is fixed for argument. There was no stage for DW2 and 3 came to the commissioner. No stage. Immediately after closure of DW1, we had filed the application for re-examination.
Actually, when DW1 was completed, that time they did not approach the learned commissioner. Thereafter also a gap of 1 month's gap was there for filing commission report before the learned trial court. They should have come with their witnesses. They should have cooperated with the learned commissioner. What prevented them to make necessary contact with the commissioner?
Okay. Part Mr. M.J. Kadir, learned counsel for the petitioner. Part Mr. From respondent number. The office note dated 8/9/2025 seen that the notice issued to the respondent number return served with a note in red command no such addresses RPS. It is submitted by Mr. Kadir that they do not have any other address of the respondent number 2, and the address which has been mentioned is only from the plaint, and this is the mention which was address is mentioned as per the plaint of the original suit. Accordingly, Mr. Kadir submitted that he may be allowed to take steps through the alternative mode, that is through paper publication to the respondent number 2, who is a registered firm, which is a registered firm. Next part, Mr. Sharma, the learned counsel for the respondent number 1, submitted in this record that in the learned trial court below also the case proceeded ex parte against the said firm of the respondent number 2. Next part, considering this submission made by the counsel, the petitioner is hereby asked to take rest to the respondent number 2 of the respondent number 2 through paper publication, where the farm was located in which place in Guwahati?
Guwahati.
True. Publication in white, 2 widely circulated paper, one in English and the other one in a vernacular language. After finishing the notice to affidavit. Yeah. The petitioner will take steps accordingly and will also file the necessary affidavit and the paper cutting, etc., before the registry on or before the next date of listing. It will take some time for publication.
Yes,
and
ma'am.
all.
Of
So
course, 4 weeks, 4 weeks, 3 weeks time, specific time may be given.
specific time means you want date fixed.
Yes,
It
yes.
may not be possible. I think
Within 7 days or
he will take step.
We will take, my lord. But it will.
But date may not be
because it is suit originally belongs to the year 2012, almost 13 years old.
I can understand, but the date.
I am for the
may-
plaintiff actually before the trial.
Oh, he will-
I'm suffering actually.
Yes, so date specific.
My premises has been burned down.
If you insist on a date, then it will be on 25th of March.
25th
March.
obliged also.
My lord, the interim order is, my lord,
Interim was there.
or there.
Interim be continued.
Maybe.
Obliged.
Oh,
Wait a minute.
May I please allow? So as per office note dated 31/26, notice by registered post has returned unserved. And usual process is not received by the section. We are positive about the address, lordship. We may be allowed to take Dasti style.
Sole respondent.
Sole respondent.
You are Mr. D. Mujum. You are
D.
Mr.
Majumdar.
D. Mujum. D. Mujum. And counsel for the appellant. A, as per the office note, dated 30/01/2026. The notice returned unserved, and service of the usual process is still awaited. It is submitted by Mr. Mujumdar that the appellant may be allowed to take fresh steps through Dusty mode. Dusty mode. That the prayer is allowed. The appellant will accordingly take steps to the sole respondent through Dusty service and will file the necessary affidavit. List the matter accordingly after 3 weeks as on a week expected.
Then I am allowed. Interim order passed early may be continued.
Interim was there.
Yes, interim order is there.
I click for hard students will for interim order. We continue till next day.
Much of it.
Yes, you got the instruction.
Lordship, respondent 4 may be deleted. Yes, Lordship.
RMS as Musami, the learned counsel for the applicant. Now, MS, you are
DL Deka, Your Lordship.
DL Deca appearing for the respondent number 1. The office also reviews that services already completed on the respondent number 2 and 3. Further, from the affidavit filed by the appellant in regards to service of notice on the respondent number 4 to Dusty mode, it is seen that the respondent number 4 refused to accept the notice through her telephonic conversation, but there was no personal service to the notice through Dusty. Next part, MS Musa, the learned counsel for the appellant submitted in this the respondent number 4 that marriage and accordingly pay to strike out the name of the respondent number from the cost of the memo. Considering this action made by the counsel for the name of the respondent number 4, we strike the cost of the memo at the risk of at the risk of the raised to be in that regard, it can be listed for. It is
Yes,
already
Lordship.
admitted, na?
Yes,
Yes, Your Lordship.
the TCR also arrived.
TCR also. As TCR has already been received. Accordingly, case may be listed for final hearing after 3 weeks as on a date of expectation. It will be
Obliged.
listed.
Obliged.
Wait, please, Your Lordship. Your Lordship, the respondent has appeared, Your Lordship, in this case, Your Lordship. Let Madam come up for admission, Your Lordship.
It is an hearing.
Is this the sole respondent?
Yes, your lordship.
You filed your Wakalatnama also.
Yes.
Your name is already reflected.
Name is written, but record is not there, your lordship. The name record of the Wakalatnama is not there in the record, your lordship.
Your Wakalatnama is not in the
But they
record.
have already filed.
Most probably filed there as the name is already reflected.
Name is reflected.
But you just peruse the record. If it is not available, then file it, because in the subsequent it may create some problem. So let us see. Heard Mr.
S. Diffusa, your lordship.
S.
Diffusa.
Heard Mr. S. Diffusa, the learned counsel for the appellate, and also heard. You are P. Upadhyay or A. Upadhyay? P. Upadhyay, the learned counsel appearing for the sole respondent. Does the services already completed? It is not yet admitted, I think. No?
Not yet admitted, your lordship.
You are going to list in the admission column?
Yes.
Because record was also not called
Yes,
for, I
yes.
think, no?
On the last day, the record was called, your lordship, on the first day.
Called for,
Yes,
not,
lord.
not received.
Not received, your lordship.
Record of TCR has not been received. The registry is hereby directed to issue reminder. Let the matter be accordingly listed for admission hearing. After 3 weeks will do, but we cannot fix the date.
After 2 weeks, your lordship.
3 weeks will the matter be accordingly listed after 3 weeks as an ended 2 weeks by the registry. We call it
Obliged,
for the
your
case record.
Obliged.
So the matter has become infructuous, my lord, as the opposite party has withdrawn his divorce proceeding, my lord.
Oh,
My lord, the matter may be withdrawn. My lord.
Heard Mr. V.K. Burman, the learned counsel for the petition. It is submitted by him that during the pendency of the present transfer petition, the respondent had already withdrawn the divorce petition being registered as TS D, case number 34 of 2025 from the court of Learned District Chester. In view of this, the present petition become infructuous and accordingly paid. Considering this submission made by Learned Counsel for the petition, the present transfer petition is disposed as rendered infructuous.
Highly obliged.
My pleasure, lordship. In this matter, service is complete, lordship.
You have already.
We have already paid for both
How
the
many?
respondents.
Both the respondents.
LCR has also come most probably.
In the cause list, it has been reflected. The cause list, it has been reflected.
Yes, cause list.
In the cause list, it has been reflected.
Yeah, we have received.
Maybe fixed for hearing.
Part Mr. D. Chaudhary, the learned counsel for the appellate, and also part Mr. S.K. Poddar, the learned counsel appearing for the respondent number 1 and TCR has already been received. Let the matter be accordingly listed for final hearing. How many weeks you need? So we may not be possible
As per your
on our part to fix a date.
Most probably matter will be compromised. Compromise talks are going on between
Some compromise talk is also going. The last part of March.
You want fixed date here?
No.
As your lordship thinks.
This will be on the first week of March. Then in that case, it may be adjusted because date may not be possible. That's why let the registry, let the matter be listed accordingly on the first week of March. And swing, first week of March as on a date. Let us see if compromise is there, then you can mention.
Talks are going on, lordship. Matter between brothers and sisters.
Oh, very nice.
Problem.
That is a lordship. The matter, the issue here is a very small issue.
What happened? Two persons in a probate suit, two persons filed one application for including them as guardian ad litem for one defendant, one of the defendant, substituted defendant. We had no objection since a medical report came that this defendant is unsound mind. There is no, we have not objected to that. But what happened while passing the order, the learned trial court implicated both the applicants as party defendant.
Oh,
That cannot be done. But Lordship can just take page 51, paragraph 9.
no, it is in order column. Are you ready?
And on last occasion,
Respondent lordship.
Huh.
Both the respondent I have.
So
that can be disposed only just that much we are aggrieved of.
what about yours? Okay.
Paragraph 9 of page
They
51.
they cannot be granted as a substitute.
Yes.
They may be granted as
Guardian ad
guardian
litem.
ad litem.
Guardian ad litem, huh? Yes. So which means
Only one,
Deleted.
only one,
They
because
may be deleted, madam. The substitute one. Yes, yes.
kindly see paragraph 9 of page 51.
51.
51. Because the court has already appointed guardian ad litem. Apparently, the petitioners are relatives of Srimati so-and-so, and they have been looking after her. Petitioner Sri Rajesh Medhi is her maternal uncle, and presently she has been residing with him. Under these circumstances, petitioner Sri Rajesh Medhi appears to be the fit person for appointment as guardian and guardian ad litem for Srimati so-and-so. Accordingly, Sri Rajesh Medhi is appointed as guardian ad litem.
That part was okay.
That part is okay. Then last paragraph 10, here the problem occurred. The petitioners, namely so-and-so, Rajesh Medhi and Sri Kingshuk Chaudhary are substituted as defendant numbers 8A and 8B, respectively, along with Srimati Barnali Medhi. This Barnali Medhi is already substituted as defendant number 8A. So here Rajesh Medhi should be appointed as an guardian ad litem only, not as a defendant.
And
That part
then
only.
now who is this Kingshuk Chaudhary?
They both of them
applied
for guardian appointment as guardian letter. Court granted only Rajesh Medhi.
Rajesh Medhi. Okay. So
That
if
part
I
only.
the present petition, you want to only do
Only this Rajesh Medhi should be appointed as guardian ad litem and
not
both
as
of-
a
not as a party defendant. Neither of them.
part. Mr. Idhar, the learned counsel for the petitioner, also had Mr.
M. Das.
M. Das, the learned counsel appearing for respond number 2 only or appearing?
Respondent
One and-
1 and 2.
1 and court respond number 1 and 2. Then petition. The 27 Constitution of India, dated section 115 of CPC, challenging the order dated 5/5/2025 passed in connection with petition number 1948 of 2022. Petition number is 1948 and what is the case number?
Case number PTS number 5 of 2018.
Arising out of PTS
5 of 2018. Stop. It's written.
arising out of PTS number 5 of 2018. by the learned additional district judge number 2, Kamrup M. Guwahati, in a case filed by the respondents as in probate title suit number. No, not right. Respondents went. Next paragraph is submitted by Mr. Gaur, the learned counsel for the. So in that case, you were the respondent. I mean, defendant.
I am the plaintiff there
In the probate suit,
in
you were the,
probate suit.
you were the plaintiff.
I'm the plaintiff. And this Barnali Mehdi was
Was the
the
defendant.
substituted defendant number 8A.
Right. Is submitted by the learned counsel for the petition that in the probate suit, the defendant number 8A, Srimati Barnali Mehdi, was admittedly suffering from unsoundness of mind, and she was not capable of protecting her interest. Accordingly, one petition was filed by two applicants, namely one Rajesh Medhi and King Shuk and one King Shuk Chaudhary, to appoint them as a guardian ad litem for the respondent number 8, Srimati Barnali Mehdi. The learned the said prayer filed by the plaintiff respondent, comma, the present said petition prayer filed by the present respondent plaintiff was not objected by the petitioner side, and accordingly the prayer was allowed by the learned additional district judge. However, while passing the order in para 9 of the said order, the prayer for appointment of guardian ad litem was allowed, and Sri Rajesh Medhi, considering the Rajesh Medhi to be a fit person for appointment of guardian ad litem, the court had accordingly passed the order. But in para 10 of the said judgment, it was ordered that the petitioners, namely Rajesh Medhi and King Shuk Chaudhary, are substituted as defendant numbers 8A and 8B respectively, along with Srimati Barnali Mehdi in place of the deceased defendant number 8, Srimati Vandana Mehdi. Srimati to Nirima Maran. Accordingly, it is submitted by Mr. Gaur that the two petitioners who applied to appoint them as a guardian ad litem cannot be imputed or substituted as a party defendant to the said suit. Next part, Mr. Das, Mr. Das, the learned waiting for response number 1 and so raised no objection and submitted that the name of the respondent, name of said Rajesh Medhi and King Chaudhary may be deleted or strike out as a party defendant, and they may be imputed only as a they may be appointed only as a guardian ad litem for Srimati Barnali Mehdi. Considering the submission made by Learned Counsel, I have also verified this recordedly order passed by the learned additional district judge in PTS number 5 of 2015, dated 5/5/2005, is hereby altered or modified to the extent that the petitioner Sri Rajesh Medhi be appointed as a guardian ad litem for Srimati Barnali Mehdi, who is already imputed as a legal heir for the deceased defendant number 8, Vandana Mehdi. Into that orders will is thereby interfered by illegally. Okay, then we are
Published.
disposed to.
My lord, I'm praying for item number 43, my lord. I will not be available at the second half, my lord, because I have a
40?
matter at
Oh, no, no.
room
What is
number one.
number?
43, but it will come up next week. Yes, no objection. Item number supplementary.
43 in the orders column.
Orders.
That is for one condonation delay was there.
Delay, my lord.
So you want in which date?
Any day, my lord, next week.
Next week? Next week? Not possible. These are not possible. I look at the request made. You are for the petty appellate?
My lord.
You're for the appellate. The request made by the Learned Council. Yeah. 16th of March. Oh, sorry, 16th of February.
Obliged. Obliged.
My lord, pursuant to order of this honorable court, the insurance company has deposited 50% the awarded amount. And we have filed an IA, my lord, for release of the same.
Lordship, first of all, the IA itself is not maintainable because they have not made the owner and driver party to the IA. And the tribunal's judgment was for pay and recovery. We have come against that, or pay against that itself, the pay and recovery. And without notice being served on the owner and driver, Lordship, how can Lordship can pass the order for release? I have judgment of our own High Court when the court has given direction that the owner and driver are necessary, and only after their appearance, this application is to be decided. So they have
Apart from that, as it is a pay and recovery case, so you have any objection there?
Yes, we have objection, but preliminary objection is that, Lordship, without presence of the owner and driver, this petition cannot be allowed. They can amend the petition and add the owner and driver, no issue with that.
My lord, I disagree with my friend. It is not necessary, my lord, to bring them into the IA because already notices has been issued by this honorable court, and pursuant to the order of this honorable court, a statutory appeal, they have deposited 50% of the awarded. Now, whatever the result comes, my lord, result will follow. And there are a number of judgments, my lord, where pay and recovery is already there, my lord. We will find bond, my lord, if necessary. Like other day, your lordship has passed an order. Oh, we will find bond.
Probably their intention is that though the parties are there in the original case, I mean the appeal, the driver owner, they are the party of this case.
Yes.
But most probably with the intention that this is the case only praying for the release of the deposited amount, that is the 50% of
But we indemnify the owner as it
you
is.
have to indemnify the owner.
So without the owner being present, Lordship, how can we indemnify him? This will be this is a IA, so Lordship, that indemnification is there, so they have to. So they are objecting to it.
Yes, that is one.
Indemnification is as such directly the insurance company is not liable. We are only liable because the owner is liable. And in absence of the owner, Lordship, how this petition can be decided? That is my preliminary submission. Indemnification is there.
Do one thing, better to avoid this thing because he's rightly pointed out, because indemnify has to be by this owner, because this is a pay and recovery only. So in that case, to the owner driver will be the necessary party, because if the order is passed, suppose for the indemnity bond also, in that case also, to whom to indemnify? This is the owner and
We will indemnify the insurance company, my lord.
no,
Suppose
they are
we-
not directly, they are not liable. This is the pay and recovery. In the
Yes,
case
my
of
lord.
pay and recovery, they are not directly, they are not responsible or liable. So better to make party, I think. Otherwise, if it is suppose not maintainable, again it will create problem.
Yes, Lord.
Apart from that, whether we have
My lord,
received
my
the LCR,
No,
this
that
year?
has not, though it is from Kamrup itself, Lordship, it can be finally heard also. That is also my submission. But from Kamrup, we have not sent it. And the Lordship, office note dated 31/26 says that respondent 4 and 5 awaited and LCR not received. So reminder for LCR can go.
Reminder for LCR going to go, but the 4 and 5 is still awaited.
That is why, Lordship, I say about the usual process notice that Lordship will pass an order in the appeal also that registry will verify whether the speed post, because we had taken by steps by AD as well as usual process. That means speed post. So registry will verify the service.
My lord, what I understand from the Supreme Court judgment is, my lord, insurance company is liable to indemnify the claimant first. And whatever payment is made will be recoverable from the owner later stage. Now, owner does not come here for payment of 50% money, my lord. Even if 100% is deposited, my lord, pursuant to dishonorable courts, we are entitled to receive it, my lord. Somebody has expired from my family and I'm running hand to mouth in existence. Now one argument has come, owner. You take care of owner.
Lordship, when you is coming, Lordship, then I'll file my formal objection to the petition. Lordship will give me a 2 weeks time.
My lord, what prevented my friend from filing objections?
No, I received it on 31, Lordship. Just 2 days
First
back.
day, right?
30. I received it on 30th, maybe 31st day. When do I get the time to file my objection? Just last week it was served out.
What I'm on that, obviously, it is the insurance company to deposit the money, or they have already deposited. But the question is that it is a case of pay and recovery.
My lord.
So, why owner will take the responsibility? Suppose if the expertise is there, suppose owner is to be heard because they will say something as they may say that the insurance policy was valid at the time of insurance liable policy. This kind of submission may be from their side. So do one thing. We could have heard the entire matter, in fact, but the
Yes, my lord.
case is not. I mean, case record is not available, na?
Lordship
It
can
will
call
be
it
required.
because it is from Kamrup only, Lordship. This is from MSCT 2.
My lord, that is will be the right approach, my lord. Let the matter come up before your lordship with for final hearing. We will submit whatever we have.
Because not 50%, that way they get 100%. If the case is heard, Lordship, and Lordship, we need that direction as per Nanjappan. That is what is our about pay. So they get 100%, no need for 50%. But then I want that expeditiously hearing, Lordship, expeditious hearing. So registry, Lordship, can
Do one thing. I'm not passing any order in this. It's just simply you want to file your objection. Any objection?
Yes, but if he wants
Also,
that finally
I'll
heard.
make a mention that objection, and you also raise the issue of maintainability of the present petition.
Yes.
So, in that order, we'll
And in
hear the
appeal, Lordship will call for the records
Okay.
expeditiously and the report from registry, Lordship, because we took steps long time back.
I to heard Mr. H. Das, the learning counsel, appearing for the applicant respondent, and also heard for the appellant respondent.
Marjorie Moon, appeal number 2.
This
number
2. Paying for which
But
will
her
be
legal ad
50%
is
deposited
temporary.
amount for the registry. In that case, MS Mojumdar, the learned for the respondent submitted that the present application is not maintainable in the present form, and they also want to submit their objection in that regard. Let the matter be accordingly listed. In I appeal date may not be fixed because LCR we have not received.
No issue, Lordship. But Lordship will read expeditiously the LCR
Okay.
report
Yes.
of usual process as well as
The 2 weeks as an date to fix by the 2 weeks as an date to fix by the registry along with the MSc appeal number 526 of Victoria. Next, MSc appeal audio. Hardens MS R.D. Mujumdar, the learned counsel for the applicant, and also heard Mr. H. Das, the learned counsel appearing for the respondent number 1, 2, and 3. Stop. It's the
Hearing
note. It's not dated.
31
dated 30/01/2026. The AD card for the respondent number 4 and 5 is still awaited, and LCR is also not received. In that regard, it is submitted by MS Mujumdar that QST may be directed to track the consignment report of the in respect of respondent number 4 and 5, and for the usual process, the service may be awaited. Post op. Considering the submission made by learning council for both sides, the registry is hereby directed to issue reminder asking the learned trial court, learned member MSCT to send the record on or before the next date of listing. At the same time, the registry is also hereby directed to place the track consignment report for the in respect of respondent number 4 and 5. Further, the service in the usual process be awaited till next date of listing. We are listing after 2 weeks only.
My lord, can it be listed on 26th of March? We will also try from our side to bring the record here, my lord. The date may be fixed, my lord.
I do not have any.
26.
One small problem, my lord. Respondent number 2, I have submitted a death certificate, my lord. Expired 24/6/2025, my lord. Her name may be strike out. Two is the mother, my lord.
She was
3 is the
mother of
daughter, minor
deceased.
daughter.
Mother of the deceased.
2 is the mother of the deceased.
And 1 is the wife.
1 is the wife.
And 3 is the minor daughter.
3 is the minor daughter, 7 years.
And
They say there are no legal heirs.
There's no other legal heir.
no other legal heir.
No.
Only wife and minor daughter was there.
Will remain, my lord. Oh, mother will go out.
Lordship will mention that because otherwise what happened, someone might someday crop up and say, "Ki, I'm also a legal heir," so that there are no legal heirs, Lordship will mention.
Mr. Dalsila Mr. Dalsila counsel for the respondent further submitted that during the pendency of the present appeal, the respondent number 2, Subhadra Biswas, died, who was the mother of the deceased, and she died without leaving any legal heirs to be substituted in her place. To substantiate the plea, as the respondent to certificate issued by the concerned authority. Considering this submission made by learned counsel for the respondent, let the name of respondent number 2, Subhadra Biswas, Surabala Biswas, be struck out from the first title of the memo of appeal. I have recorded their submission that she left behind no legal heirs. So there is none to be substituted in her place. So accordingly, her name is
fine.
In that case, you may not be in a trap.
Yes.
Okay. Legal heirs.
Highly obliged.
Okay. You may take it.
May it please your lordships. In this case, my lord, in this case, my lord, there were some mistakes, my lord, inadvertent mistake, my lord. In this case, my lord. For,
what kind of?
My lord, the provision should be, my lord, under order 41, rule 19 of CPC, read with section 151 of CPC, my lord. But it has been, my lord, inserted as order 9, rule 19, my lord. My lord, typographical mistake, my lord. Otherwise, there was some copy paste most probably, my lord. And the main case, my lord, we have filed IA for restoration of, my lord, RSA.
It was dismissed.
Dismissed for default, my lord. That is in this case 22, my lord.
So now the proper section would be 40.
My lord.
Proper section would be
Proper section is, my lord, Order 41, Rule 19, read with section 151 of CPC, my lord. That is.
So in that case, either you have to pray for an amendment here of your cost title.
Yes,
or
my
you
lord.
can through an additional affidavit also. You can submit.
I will file, my lord, but or otherwise, my lord, I may be allowed to, my lord, correcting, my lord, in post title, my lord. Yes, sir.
Nowadays it's not possible.
Then I will file additional affidavit.
Yes. So the RSA was dismissed for default.
Default, my lord. And there was, my lord, delay, my lord. A delay has already been condoned by this
That has
honorable.
already been condoned.
Already condoned. And now, my lord,
After condoning the delay, the
My-
RSA is registered.
yes, yes, ma'am. No,
Oh,
not
no, it
tested,
was restored.
not tested. Now, my lord, the miss case, my lord, 22/25, that should be hard, my lord.
For restoration.
For restoration, my lord.
Delay part is
Delay
already.
part is already condoned.
IS bill 195 would be. Oh, I see. Not in Miss case or tipo, Miss MC case number 22/2010. Heard Mr. S. Amit, done it for the applicant. Mr. J. Ahmed name is here, he is not
My lord,
here.
I have already informed, my lord, most probably, my lord, for simple correction, that's why, my lord, most probably.
For the response. So, the name of council is reflected in the context. Next, Mr. Ahmed, Senate Council, the applicant appellant submitted that the there's a typographical mistake while filing the present application. The application ought to have been filed under Order 41, Rule 19, read with Section 151 CPC, but inadvertently it had been filed under Order 9, Rule 9 CPC for restoration of the RSA number 82 of 2021, which was dismissed for it. Next, in view of this, the applicant is hereby directed to file an additional affidavit with correct and proper order and sections of CPC, praying for the restoration of RSA 82 of it. How many weeks you need here?
My lord.
How many weeks you need?
My lord, I will file, my lord, on my lord, tomorrow I will file, my lord. As because, my lord, the execution is, my lord, is there, my lord. That's fixed on, my lord, 16th of February, my lord, for final order execution, my lord. So we are taking some time, my lord, in that court. As because, my lord, kindly fix it on 10th, if possible, my lord. 10th of February, my lord. I will file tomorrow, my lord. Otherwise, my lord, that order may be passed in trial court.
11th of February. 10th is not possible.
11th of, my lord.
February.
Oblige, my lord. Much oblige. Oblige.
May I please, Your Lordship? Lordship, this is the petition for condonation of delay, my lord.
So this is first time it has come. Now, how many days delay was there? Delay was for
76 days, my lord.
76
days.
I would say not a, it's a big, not number of days, it's not so long delay. There's no long delay, but the question is that you have to issue notice. First time it has come.
Okay.
So you are MS? You are MS? Your
PDAS.
PDAS. Part MS PDAS. The learned counsel for the applicant. This is an application under Section 5 of the Limitation Act for condonation of delay of 76 days in preparing the connected appeal against the judgment in decree dated 5/4/2025 passed by Civil Judge Senior Division Kamrup, Amin Gaon, in mistake case number 264 of the 2024 in connection with TS number 148 of the let the notice be issued to the respondent through speed post and as usual process. Let the matter be listed accordingly after 3 weeks as on a date. You take steps today by within 5 days. We'll fix it up after 3 weeks. God bless.
Or I am from
Oh, you have already appeared?
Yes.
Acha, acha. Okay, then we'll modify, verify to some extent. Yeah, hard non-appears will display the hard Mr. G. Ahmed will be. Simple correction he requires.
I have no objection.
Obliged. I was in. Keep go ahead. I guess, Mr. Sharma, what was there? Is
Yeah, in this case, I am the plaintiff in the trial court. I file a suit, seeking declaration of right title interest. And the declaration that my house.
No, yeah, the respondent already appeared.
Respondent appeared. Has
Appeared.
appeared. Yeah, in this case, I file an application under Order 26 Rule 10 of CPC, read with Section 151 of CPC for appointment of a commission to ascertain by field inspection and measurement whether the southern wall of the house of the plaintiff is standing on Dag number 1130 of KP Pata number 184 or the Dag number 1875 of NK Pata number 13 of Khata Mauza, Nalbari town. This is the prayer measure. My application, your lordship will find at page 72, annexure 5.
Originally, you were the plaintiff.
Plaintiff. This suit had to be filed because of disturbance created regarding repair of my wall of the house, for which determination of which melody is required by the report of the commissioner. I'm reading the application.
Yes.
That this petitioner is plaintiff of this suit. The suit is fixed today for PW evidence by affidavit. I have already submitted my evidence in chief as PW1. That this suit is filed by the plaintiff as because the defendants did not allow the plaintiff to erect one wall on the adjacent inside of the southern wall of the house of the plaintiff. That it is true that the defendant is southern neighbor of the plaintiff and the defendant has purchased land in Dag number 1875, which is at the adjacent south of the Dag number 1130, where the house of the plaintiff is standing. That now the defendant is not allowing the plaintiff to do work on the southern wall of this house, claiming that the wall is on her land of Dag number 1875. That as the real dispute now stands on the point whether the disputed wall of this case is standing on the Dag number 1130 or Dag number 1875. that the plaintiff now pray before this court for obtaining a report from the Revenue Circle Officer of Nalbari to clarify the point whether the southern wall of this house of plaintiff standing on Dock number 1130 or 1875. The Revenue Circle Officer can clarify, clearly find that with the help of the map, Gunia and revenue staff, including Lot Mandal and SK, plaintiff shall bear the necessary cost. So this is my application with the prayer to ascertain the issue concerned that whether my wall of the house stands on Dock number 1130 or on the plot of land of which was purchased from me by the defendant, that is situated on 1875 of NK Pata number 13. Their objection is at page 74. That the petition filed by the plaintiff under Order 26, Rule 10 of CPC is not maintainable both in law and facts. The plaintiff has filed the main suit as well as the present petition by suppressing the material facts, as the subject matter of the present suit has already been decided in TS 5607 and TS 34 of 13, which was preferred by the plaintiff of this suit, and both the TS 5607 and TS 3413 has been dismissed by the Munsif number 1 Nalbari. Hence, the petition of the plaintiff is liable to be rejected. That the present petition and suit of the plaintiff is not maintainable both in law and facts, as the same is barred by principle of res judicata as provided under section 11 of CPC. That initially plaintiff had filed the suit by the TS 56 of 2007 against the defendant, her husband, and also the vendor of her sale deed, wherein he sought relief for declaration of right title interest and for recovery of possession of the land, which is included in the suit land. It is the land of suit Dock number 1130, Pata number 184. That the suit was dismissed by the Honorable Court by judgment and decree dated 28/02/2011. Plaintiff preferred appeal by title appeal number 3 of 2011, and the Honorable Civil Judge Nalbari also dismissed the appeal by judgment and decree dated 8/3/2013. The crux, the issue of right title interest of the plaintiff over the suit land has already been decided in the same previous suit. An appeal in between the same parties, and thus the present suit is totally barred by section 11 CPC, and therefore the present petition is not at all maintainable. And before filing this case, suit land has already been demarcated by the concerned Lot Mandal and previous suits filed by the plaintiff. Hence, the present petition is not tenable at this stage. Here, the dispute is regarding my wall, whether situates on Dock number 1130 or not regarding the land which is pertaining to the other two civil suit. My plaint is at page 53, my lord, and the relief portion, your lordship may kindly see what relief I have sought for in the suit. At page 64, my lord, relief of the relief sought for by me in the plaint. Declaring that the southern wall of the house of the plaintiff is standing on Dock number 1130, which is described in Schedule C, and the plaintiff is the absolute owner of the land and house, having its right title interest and provision. Here in this case, the house that is owned by me, that is on Dock number 1130 itself, my lord. The Dock number 1130 has more than the amount of land which was decided in earlier suit, and rest portion, in the rest portion of that DAG number 1130, that house is situated. So this will be decided whether res judicata is there. In this case, that would be decided while entire suit is decided. In a petition for appointment of commission, how the res judicata question that will come, my lord, because evidences, the suit is proceeded now. Suit is proceeding now. That preliminary question of res judicata, that was not heard, and this is not the object of the defendant also. The question is whether a wall that of my house, repairing of which has been obstructed by the defendant, that question is to be decided whether that wall is situated on DAG number 1130 or not. For to ascertainment of that, the application was filed for appointment of a commission, because the circle officer is the revenue authority, is the best judge to decide it. Even the civil court also, by through evidence, it cannot be decided without consultation of map and regarding land record, etc. It cannot be decided by the civil court. Civil court will have to depend upon the report of the commissioner to decide the suit, as because the suit is continuing. At this stage, evidence has been closed in respect of plaintiff. So your lordship will now see this order what has been passed in respect of my application, rejecting my application. That order is at page 96, annexation 9. Today, with this order, I shall dispose of the petition number 611/23, filed by learned counsel for the plaintiff petitioner under order 26, rule 10, read with section 151 of CPC, for appointing circle officer, Nalbari Revenue Circle, as commissioner for local investigation. Petitioner plaintiff stated in petition, by petition number 611 of 23, that the suit is filed by him as because the defendants did not allow him to erect one wall on the adjacent inside the southern wall. So that wall is not beyond the outside the wall of the house, but inside the house wall of the on the adjacent inside the southern wall of his house. The petitioner plaintiff further stated that the defendant is his southern neighbor, and the defendant has purchased land in DAG number 1875, which is at the adjacent south of DAG number 1130, where the house of the plaintiff is standing. The petitioner plaintiff further stated that the defendant is not allowing him to do work on the southern wall of this house, claiming that the wall is on the defendant's land of DAG number 1875. The petitioner plaintiff stated that as the real dispute now stands on the point whether the disputed wall of this case is standing on DAG number 1130 or DAG number 1875. The petitioner plaintiff has prayed before this court for obtaining a report from the Revenue Circle official Nalbari to clarify the point whether the southern wall of this house plaintiff standing on DAG number 1130 or 1875. The Revenue Circle officer can clearly find that the help as map, Bunia, and revenue staff, including Lapmandal and SK. The petitioner further stated that he shall bear the necessary question. Copy of the petition was furnished to the other side. The opposite party defendant submitted written objection. The opposite party defendant denied the claims and allegations of petitioner plaintiff. The opposite party stated that the plaintiff has filed the main suit as well as the present petition by suppressing the material facts, as the subject matter of this present suit has already been decided in TS 5607 and TS 34 of 2013, which was prepared by the plaintiff of this suit, and both the TS has been dismissed by this court. Hence, the petition of the plaintiff is liable to be rejected. It is further stated that present petition and the suit of the plaintiff is not maintainable both in law and fact, as the same is barred by principle of res judicata as provided under section 11 of CPC. The defendant stated that initially plaintiff had filed the suit by TS number 5607 against his defendant, her husband, and also the vendor of her sale deed, wherein he sought relief for declaration of right title interest and for recovery of possession of the land, which is included in the suit land, that is the land of suit Dak 1130 of Pata number 184. The opposite party stated that the suit was dismissed by this court by judgment and decree dated 28/02/2011. The plaintiff preferred appeal. The Honorable Civil Judge, Junior Division, Nalbari also dismissed the appeal by judgment and decree. Thus, the crux issue of right title interest of the plaintiff over the suit land has already been decided in the said previous suit, and appeal in between the same parties, and thus the present suit is totally barred by section 11 of CPC, and therefore the present petition is not at all maintainable. The opposite party stated that before filing of this case, suit land has already been demarcated by the concerned lot mandal and in previous suit filed by the plaintiff. Hence, the present petition is not tenable at this stage. The submissions put forward by learned counsel of both sides also peruse the case record. The plaintiff petitioner has filed the instant title suit against the defendant opposite party for declaration that the southern wall of the house of the plaintiff is standing on the tag number 1130 of KP Pata number 184 in Nalbari town. Pata Moja, Post Division PS Nalbari. The opposite party defendant has opposed the prayer of the petitioner plaintiff and stated that the instant suit and the present petition is barred by res judicata as the subject matter. Our present suit has already been decided in TS 56 and TS 34 of 2013. It is seen that both the title suits were preferred by the present plaintiff petitioner and dismissed by this court. In both the title suit, it was decided that the plaintiff has no right title interest over tag number 1130. It is not correct, my lord. Right title interest over entire 1130 land, that is not there. There are only 6.5 acres of land that was sold to the defendant. In respect of that, my lord, that is there, but it has been without evidence on the base or the records of the two suits. This finding has been arrived at. The plaintiff petitioner preferred appeal against the decision passed in TS 56 2007 before the Honorable Court Civil Judge Senior Division Nalbari, and it was registered as title appeal number 3 of 2011. The learned Civil Judge Senior Division dismissed the appeal by judgment and decree. As such, I do not find it necessary to issue commission to clarify whether the southern wall of the plaintiff is standing on tag number 1130 or 1875. Accordingly, prayer of the petitioner number 611 to 23 is rejected. The entire suit has been decided by the finding of this order measure. On the other hand, the suit is going on with the evidences on the records. The evidences, the plaintiff has completed his side, melody. So far, evidence is concerned. Now, the res judicata issue, without that cannot be decided, without the case records, without the evidences of those suits, and since it is a mixed, relates to the issue, mixed question of facts and law, so it should be decided while it is decided by the in respect of the entire suit. So the application that was fairly filed, and here it is not clear. Even here is not discussion regarding that whether tag number 1130, how much land is there in respect of the plaintiff in that tag. That is also not discussed. Only declaration of right title interest that was rejected in respect of the plaintiff's defendant's occupied land, which was sold to her in earlier occasion, and for that reason, two suits were there, and both the suits I lost. It is correct. I am not opposing it, but the house which is standing on the land of the tag number 1130 in my portion of land, that is an inside the boundary, inside the wall of the house. The repairing work is going on, that has been obstructed, that has, for that reason the suit had to be filed. Now, Maladi, the question whether walls stands on the plaintiff's land, that can only be decided by a commissioner's report, and that too by the revenue authority, and not beyond that much. I'll cite two decisions in this respect.
Is there any clarification in that earlier judgments that because the court had observed that the earlier settled suit,
Yes.
it is declared that you don't possess any rightful interest over DAG 1130.
That DAG
But is
11
there any clarification that much land was in his
No.
possession?
Yes,
And that about
yes,
rest
yes,
of the
yes.
land is in your possession?
Yes, only 6.5 places of land of DAG number 1130.
6.5 places of land was only the disputed land in the said case?
In respect of which the suit was, my suit was rejected.
In that suit, only 6.5 places
6.5 places of land,
was the suit land.
suit land, in respect of DAG number 1130. Even, my lord, logically also, my lord, if this sort of finding is passed, my lord, passed in a miscellaneous application, then what is the necessity of proceeding the entire suit, my lord? If from the res judicata it suffers the entire suit is to be liable to be dismissed, then why the suit is proceeding, my lord? So on that logical point also, my lord, this application is required to be allowed, and even if it is allowed, my lord, and finding of the commissioner's report comes, my lord, then also the court can decide it on the basis of the issues framed, my lord, and evidences that will be before the court, my lord. So at commissioner's report, application for commissioner's report, that has been made in a fair sense, my lord. That since that aspect of the matter cannot be established by any sort of evidence, by way of any witnesses, evidence of witnesses, my lord, because it is a land record matter, and only the revenue authority knows in what portion of land under whose occupation and what is his right title.
One thing. In the earlier suit, you're saying that the land is particular suit land was only 6.5 places.
She encroached upon she
encroached areas, she encroached upon as per your
my allegation is she
but whatever the suit was dismissed.
dismissed.
But now in the present suit, you have
Present
your
suit-
prayer,
Present suit,
which is still pending.
page
64.
64. Declaring that the southern wall of the house of the plaintiff. My house is there, my lord. Plaintiff is standing on DAG number 1130, which is described in Schedule C, and the plaintiff is the absolute owner of the land and house, having its right title, interest, and provision. If demarcation was done in earlier suit, then how can I own this land, and how can this house, land and house can be under my possession? It is a declaration in respect of my house. I want to repair my wall by making certain construction inside the wall, not beyond the wall, my lord, not outside the wall of my house. But that has been obstructed by the defendant, and for that reason the suit was to be filed. My lord, anyway, my lord, all the issues, if it is to be resolved, my lord, then by the finding of the report of the commissioner. Otherwise, it cannot be resolved, my lord. Otherwise, that dispute will always remain, because my house is there. Lord, here in this suit only it can be decided whether that wall is situated on my land of under DAG number 1130 or the land of the defendant. That will be clear, my lord, and it will be resolved if issue is decided in this way, my lord. So I will refer a case of the Supreme Court, my lord, in this case, my lord, that is reported in 2008, 8 SCC 671. So Haryana Waqf Board versus Haryana Waqf Board 2008 671. Small judgment, my lord, I am reading it. This is an appeal filed by the Punjab Waqf Board, who was the plaintiff in a suit for declaration on injunction. The High Court in the second appeal had summarily dismissed the appeal on the ground that the second appeal was concluded by the concurrent findings of fact arrived at by the courts below. From the judgment itself, it would appear that the board had failed to prove that the respondent have encroached any land belonging to the appellant board. In view of the aforesaid position, the second appeal was summarily dismissed by the High Court. In our view, the High Court ought not to have dismissed the suit summarily merely on the ground that the second appeal was concluded by the concurrent findings of facts. The dispute that was raised by the parties before the court was whether the respondent had encroached upon any land belonging to the appellant board. Therefore, it cannot be in dispute that the dispute was in respect of the encroachment of the suit land. Admittedly, in this case, an application was filed under Order 6, Rule 9 of the Code of Civil Procedure, which was rejected by the trial court, but in view of the fact that it was a case of demarcation of the disputed land, it was appropriate for the court to direct that the investigation by appointing local commissioner under Order 26, Rule 9 of the CPC. The appellate court found that the trial court did not take into consideration the pleadings of the parties when there was no specific denial on the part of the respondents regarding the allegations of unauthorized possession in respect of the suit land by them as per paragraph 3 of the plaint. But the only controversy between the parties was regarding demarcation of the suit land, because the land of the respondents was adjacent to the suit land and the application for demarcation filed before the trial court was wrongly rejected. It is also not in dispute that even before the appellate court, the appellate board had filed an application for appointment of a local commissioner for the suit land. In our view, this aspect of the matter was not all gone into the by High Court while dismissing the second appeal summarily. The High Court ought to have considered whether, in view of the nature of dispute and in the facts and present case, whether local commissioners should be appointed for the purpose of demarcation in respect of the suit land. For the reasons aforesaid, we are of the view that the High Court ought to have considered this aspect of the matter and then to decide the second appeal on merits. Accordingly, we set aside the judgment and decree and second appeal is restored to its original file. The High Court is requested to decide the second appeal in the observation. So, my lord, here in this case, the local the stage has been given a local inspection whether how much it will be effective in respect of resolution of the issues concerned. So, my humble submission before this honorable court that without the local inspection and finding, that cannot be decided, the issue cannot be resolved because suit is continuing. Man. Or even the issue of res judicata that can be decided at the judgment stage also, after the report of the commissioner also. This is my humble submission. I pray for setting aside the order and allowing the appointment of the commission.
Here in this court, I did put in a simple matter that it is a boundary dispute, so commission. Then in that case, would not have objected. But no, is that in this case, the plaintiff is filing one after another suit for the same subject matter by making some changes by intelligent draftings. Some intelligent draftings are made and some changes are made, and the case is filed for same plot of land. Firstly, they have filed a suit that is that suit number 34/13. Actually, title suit number 34 and 13 is filed by them. Alleging that, yes, I have alleging that, plaintiff alleges that I have sold tag number 1875 to the plaintiff, to the defendant. 1875. Tag number 1875 was 15 licenses. He sold 14 and half licenses. Because why 14 and half licenses? Because half licenses is going in drain, don't for drain, construction on drain. So there remain 14 and half licenses. So he sold 14 and half. And again, there was tag number 1109 belonging to his wife. That was sold. That was 6.5 licenses. That was also sold. That in that suit he has paid for recovery of half license of that land and 1.5 license of land which was sold by wife. So that land he claimed in between the land of that godown. Presently the suit is regarding one godown in tag number 1130. So that land he was claiming between 110 and 1130 and these two racks. That is around 2 feet of land. 1 lacha and 1.5 lacha. That he claimed there. So the case proceeded, and at last the judgment was passed that no, you are not entitled to take 2 feet of land. That 2 feet of land you have already sold, and that you are not entitled. Then that judgment comes. Then again, by some changing of pleadings, he has filed another suit. So I'm sorry. Firstly, that was suit number 56/07. Whatever I have stated, that is suit number 56/07. Was mistake. First suit was that is suit 56/07. In that suit, the half lacha and 1.5 lacha, and the court decided no, you are not owner of that suit. Then again, he has filed title suit number 34/13. 34/13 was filed by him. Similar allegations, and last relief, some relief was changed. All similar allegations, but some relief were changed. So the court has found that no, all these allegations, all these things are decided in previously instituted title suit number 56 56/07. So you are not entitled to anything claim here. So that was barred by res judicata and case court was dismissed. So now he has filed a suit for some plot of land, by doing something extra. At this time, what he has done, he has, in the name of renovation of bound, it is godown, which is in backside of my house is in backside of which godown. In the name of renovation of godown, what he is doing, he has extended his wall. Just he is trying to construct the wall just by touching my wall. There is 2-3 inch difference between my wall and his wall. So he is trying to encroach that 2 feet land, which has been decided by two courts. Earlier 2 suits, it was decided that it was my land. So now he is trying to construct that wall, their wall there, by encroaching the 2 feet land. That is why we have filed a case. We have lodged FIR, firstly lodged FIR before the world. Then there was some 145, 144 CR proceeding also. There he could not construct. The wall was stopped. There he filed a suit with this time with different types of reliefs, but all the facts are same. That is why the trial court come to the conclusion that no, twice same facts has been decided by the courts twice, 2 times in 2 suits. Now you are coming with same facts with some intelligent changes in the pleadings. So the court says no. At this stage, it is not necessary. Court did not say it is barred by res judicata, but the court said no. At this stage, it is not necessary. It is not necessary. And then, Your Honor, I will try to read the plaint of both the cases. Plaint of both the cases, of both the 3 cases. But in this case, I found that written statement of both the previous cases is not there. And since Your Honor is going to dispose of the case at admission stage, I think written statement, if they may file the written statement of both the cases also. Both previous 2 cases, title suit 56/07 and title suit number 34/13.
Both the judgments.
The judgments are there, I agree. judgments are there, but written statement will show that
The question
actually
to
what is
be,
the plea taken by the defendant in that suit.
the suit
Because-
is proceeding, my lord, that is.
No, no,
irrelevant.
both the two suits. The suit is proceeding. If commission can be allowed, that can be allowed in state, that will not different. So my prayer is that I shall have to read the plaint of all the three cases. Judgment and WS is also required, because without WS, your lordship may not be able to know what was the plea taken by the defendant in those cases. So may I humbly submit that them be directed to place the WS in title suit number 56/07 as well as title suit 34/13
My lord, we can furnish it, my lord.
within
But
within
the
short
question
period,
is, my lord,
within short period.
if suit is proceeding, my lord, and if he doesn't have any objection regarding appointment of a commissioner for the fair sense of justice, my lord, then why
I am
the
objecting-
written statement is
Then I
required,
am
my lord?
objecting appointment
The
of commissioner.
judgment itself says everything, my lord. The written statements are also in the judgment. The case of the defendants and the case of the plaintiffs are there. In both the judgments we have annexed, my lord. So, my lord,
My lord,
for the purpose of resolution of the issue concerned, my lord, that can be decided only by the appointment of a commission, my lord. This is my humble submission. So it may if petition, my lord, if all
that can be decided. I don't seek any further time. Let it be fixed on within
yes, my
within
lord,
2-3 days. Within 2-3 days, and they will make them furnish the copy so that the court can see what is going on there. They are filing one after another suit for the same subject matter by just changing some drafting this way or that way. Same for same subject matter, same 2 feet of land, same around 2 lashes of land. They are fighting the case since the year 2007. One after another suit is filed, and the their lady is suffering because of their this type of things. So court has to ascertain what is going on there. So everything cannot be ascertained by just signing the judgment. I am not seeking further time. I say let it come after 2-3 days. Within that time, suit cannot be disposed of. Within that time, suit cannot be. Let them bring file the WS. Why they have filed the plaint? Why they are suppressing the WS?
There's no question of suppression of WS,
So let it come.
because the judgment itself says about their own case, my lord. Written statement, entire written statement specs that has been elaborately.
I am
Just
not
tell us one thing.
I am not seeking any lengthy adjournment.
At
2-3
this
days will come.
at this stage, my lord,
Let them file the copy. Let them submit the copy.
that
of the
issue can be decided. My humble submission before this honorable court, that issue can be decided in the judgment stage also. If it is decided at present, my lord, then why the suit is continuing, my lord? That is the logical question before. That's
So
all.
what is the
I
next
leave
date
up
of
to
the-
this honorable
my-
court, my lord.
We can say what is the next date of the suit. Let us see. What is the latest date?
No,
of
Mr. Sharma's main submission is that suppose cases, though the question of res judicata or the same subject matter, those are come up, but the question is that the case is still pending or still proceeding.
No,
In the
that is why I say what is the date,
Yes.
next date of the case.
On the other
Before
hand,
next date, we can dispose of this
it is
case.
the opinion of the learned trial court below that the right at the interest over the track number 1130 was not under his position, or he is not possessing the right at interest. So if that be the position, then the court, the case ought to have been barred by under res judicata, but still proceeding. That is his submission. So now I'm just asking you, by appointing a commission, how you will going to be effective?
That is why I say that by that one after another 3 cases are filed. 2 cases already disposed of with regard to same land. Court come to the conclusion that this is not your land. Court come to the conclusion, no, this is not your land. So
then why it is allowed to be proceeded in the
that is
other
why
case?
that there are someone has to file a application for deciding the suit on the basis on a preliminary point. Someone has to file a
Everything
suit.
will be resolved, my lord.
Someone has to file a suit there. Someone has to file a petition there to dismiss the suit on the ground of res judicata. Someone did not file that petition. That is one subject of matter. That has to be filed.
That is an issue.
It is
That
by
is
res
an
judicata.
issue to
One
be
preliminary point should have been taken by
someone
Yes,
there.
if that be the position, one preliminary issue could have been framed.
That should have been framed there,
By the
but that is not framed.
But evidence of the plaintiff that has been over, my lord.
Recorded already.
Already.
The next date is fixed there on 23 February. 23 February. So before 23 February, nothing is going to happen. Within 2-3 days, let the case come. Let them submit a copy of WS. And I shall explain
It will not
everything.
serve the purpose, my lord. If the case is continuing, my lord, by the commission's report, my lord, better it would be resolved, my lord. That will end the entire matter, my lord. In future also, no case will be there. my
If
lord,
the court comes to the conclusion that the matter which is raised in this suit has already been decided by the trial court in 2 previously suits, then whether this honorable court will want to wastage of time by issuing commissioner, that is the main issue. That is why I want copy of WS also. Let them bring the copy of WS. I don't say about 15 days time, 2 or 3 days. Let it be fixed after 2 or 3 days. The next date is fixed on 23 February. Next is fixed on 23 of February.
I can provide, furnish the WS.
Let them furnish. If they furnish, let
I
them
can furnish the WS also, but what would be the purpose?
Purpose I can explain to the court.
How it
what
will,
was the pleading? What was the pleading of the
how
court?
it will serve
And
the
what was
purpose,
our
my lord.
reply?
If this finding remains, my lord, by the order of the in disposal of the order 26 rule and petition, my lord, then that finding, my lord, already has decided the suit itself. Then what is the meaning of continuing the suit now, my lord?
That petition will be filed.
Better it's a case, my lord, if a commission is appointed and a report comes, my lord, in true sense, then entire matter will be resolved and that will end the matter for.
I cannot understand, my
future
lord, why
matter.
they are shying away from filing just copy of WS. And
It
the
is-
matter
it
may
is in
fixed
the
after 2
judgment,
days.
it
The
is in
matter
the
may fixed
judgment
after 2
itself.
days.
It is in the judgment itself.
Matter may fixed after 2 days. The judge in judgment, the plaint was not required to file. You have filed the copy of plaint.
Leave up to your lord.
They have filed the copy of the plaint. They did not find the copy of WS. Why the copy of WS has not been filed? So WS may kindly supply to WS and the matter may come up after 2 days. Let it be kept parted also. I have not done it will kept parted matter. So
The time of getting the present petition, it is submitted by Mr. Sharma that the petition is submitted with a copy of the judgment as well as the plaint, but there is no but the WS file in the earlier source plaint annexed along with the present petition, which will be required for the for the disposition. Next, but Mr. Godre raised objection and submitted that filing of WS will not serve the purpose and cannot be any reason also. Will not serve the purpose as the entire judgments in 2 suits have been furnished. Means that the petitioner is thereby asked to file a copy of WS in both the cases to petitioner activity within period and matter may be staged and petition.
In the next week, it's
At best we can fix it on 13th.
yes. It may be kept part argument.
No.
13. 13.
Much.